In the light of the submissions made by the learned advocate for the petitioner, WPA number such and such stands dismissed for non-prosecution. Yes, next.
Item number 2.
Yes.
My lord, item number 2, I'm led by Advocate Ekramul Bhatt in this matter. However, my lord,
Yes.
as per my instruction, the petitioners have been granted the relief and their grievances have been redressed.
No, it has come up for correction. Key correction.
But we have not mentioned it, my lord.
Because in para 1 line 1 instead of should be written as 226. Para 1 line 226.
Oblige.
Pass over next.
Grateful.
This what is the correction you want?
We have not mentioned for any correction.
Yes, call the next matter.
Item number 3. My lord, I have got the petitioner, my lord. Item number 3, only correction is the first title, my lord. Petitioner name is wrongly typed, my lord. My lord, name will be Omlan. Yes, my lord,
It has been
Omlan.
submitted that the name of the petitioner has been wrongly typed in the the learned advocate appearing for the petitioner submits that there is a typographical error while recording the name of the petitioner in the order dated 20th of July 2026. So, the name of the petitioner shall be corrected as
Listed visit, my lord.
let such order error be rectified. This order shall form part of the order dated 20th of July 2026. Next.
Item number 4. For
Oh,
also
yes.
say, my lord, the name on wrong. The Hawk spelling is HOQE.
Okay, I'm on this paper.
Imdadul Hawk.
First increment.
HOQEV. HOQEV. Same name of the petition. HOQEV. Octa. Yes, next.
Number 5.
My lord, one correction is required with respect of date of joining. It's mistake on our part.
Date of joining.
Date of joining. Actually, I joined on 8th March 2026. May 10, 2006.
Joined as an joined the institution as a
Headmaster
on
8th March.
8th March 2006.
Right. May 10th, it was our mistake.
All right. It has been submitted that through inadvertence. It was submitted by the learned advocate for the petitioner on 21st of July 2026 that the date of joining the petitioner as an headmaster in the institution concerned is 10th of May 2006 instead of
2000, instead of that is 10th March 2006, that is wrongly recorded, but the actual be 8th March 2006.
8th March 2006. First step, let such error be rectified. This order shall form part of the order date 21st of July 2026. Yes.
Because
Item number 6.
My lord, I'm for the petitioner. For correction, my lord, with respect to the respondent number 5, upon whom the direction has been passed, my lord, in the order it is showing district project officer. Instead, it will be district program officer.
District program officer, respondent number.
Leave was granted, my lord, for addition of the respondent number 5.
Added respondent.
Yes, lordship.
You have added the respondent.
Yes, lordship.
It has been it has been submitted that the name of the added respondent has been wrongly recorded in the order dated 23rd of July 2026. First up, the added respondent is District Program Officer, Jalpaiguri Shodor, ICDS. First up, the direction passed upon the added respondent in the order dated 23rd of July 2026 shall be deemed to have been passed against the District Program Officer, Jalpaiguri Shodor ICDS project, and not District Project Officer, Jalpaiguri Shodor ICDS project. Let such error be rectified. This order shall form. Yes, next.
Manoj, this matter is coming at my instance, Manoj. I am appearing for the petitioner.
Yes.
Manoj, the limited issue for today is, Manoj, regarding the extension of interim order because it is expiring on 31st of July. Although, Manoj, the pleading...
Yes, who is for the respondent?
For the private respondent, my lords. Can
Yes,
one
please.
is my application, my lords, for vacating of the interim order. I had mentioned this matter on Friday, my lords.
Yes.
Oh, my lords,
This is, Manoj, coming under the heading of extension of interim order, Manoj, which is expiring on
coming under the
31st of
heading of
July.
extension of interim order, my lord.
Yes.
That is the limited difficulty for today, Manoj. Although the pleadings are complete and it can be further
If I may, my lords.
Yes.
Now, my lords, I am the successful bidder, my lords, and the petitioner is the unsuccessful bidder, my lords.
Yes.
Now, my lords, the NIT was floated, my lords, for construction of Mahila barracks of my lords BSF at a BSF campus, my lords.
Yes.
Now, my lords, the interim order, my lords, was passed, my lords, on the premise that, my lords, I lack the, my lords, experience, my lords, to construct the, my lords,
Interim order was passed in your presence or in your absence.
my lords, in
In
the
his
presence of the
presence.
erstwhile
In his
advocate of the
presence.
private respondent.
That cannot be a ground for vacating.
Now, my lords, can
Certainly.
you raise me up for 2 minutes, my lords, then, my lords?
Did you satisfy the test answer order 39 rule 4?
My lords,
How?
my lords, firstly, my
It was
lords,
passed in your presence.
my lords, firstly, my lords, can you raise me up for 2 minutes? My lords, firstly, the interim order, my lords, was passed on the premise, my lords, that I did not, my lords, have the requisite, my lords, work experience, my lords. I was, my lords, labeled as a mere renovator, my lords, as to the construction of the work is concerned. Now, my lords, before filing this writ petition, my lords, the petitioner had preferred a complaint against me. And, my lords, the department had, my lords, replied to their complaint, my lords, justifying my selection, my lords. The my lords, who kindly sees, my lords, page 209 of the writ petition.
Yes, who is appearing for the respondent authority? Who is the respondent authority?
Union, my lords.
Union of India, Lordship.
Who is appearing for the Union of India?
Mr. Suyukta Majumdar is appearing. Suyukta Majumdar.
Where is he? Have you served notice upon him?
Yes, ma'am. Absolutely, ma'am.
The petitioner is the applicant in Can 1 of 2026 is directed to serve a copy of this application upon the learned Deputy
I've
Solicitor
served
General.
the copy, my lords. I'll serve a notice.
Is directed to serve a notice upon the Deputy Solicitor General of India, intimating him that this matter will appear.
On Thursday, my lords. On Thursday, my lords. Fine.
This matter will appear on Thursday. Full stop. The interim order is expiring when?
Manoj, on 31st of July. 31st of July.
Considering the fact that the interim order is due to expire, record reveals that the interim order was initially passed on
16th of April.
on 16th of April 2026, and the same was subsequently extended from time to time. Is further extended till August. When the next circuit will start?
Well, 10th of August.
Till August 14, 2026. Full stop.
If the matter
Let-
kindly be taken up on Thursday. my lord.
Let affidavit in opposition be filed to Can 1 of 2026 within August 4, 2026. List the application on August 11, 2026 before the next available settlement. Yes, next. Yes, next.
Grateful.
I'm obliged, my lord.
Yes.
My PR is not to grant the higher scale of pay, though the order was passed by this honorable court my lord, in 2014, but till date nothing has been done. My lord.
Lord, we have to
Kindly-
take instructions whether prior permission was taken or not.
My lord,
Yesterday, your lordship was pleased to direct us to consider the special bench
that is,
judgment.
my lord,
We have considered, my lord, I have gone through.
my lord, kindly see page 54.
What I have seen, my lord,
I mean,
one
আমি
glance
বলতে
that
এটা অন্য
existing
matter.
rules will guide.
No.
that. And we have to take instruction whether prior permission was taken, my lord, from the DI or not.
My lord, kindly see page 54, my lord.
54, yes.
This is the order of the honorable court.
54.
Yes.
এ ঠিক ফাইল দেননি।
Yes.
My বিদ্যুৎ কুমার বিশ্বাস। হ্যাঁ?
ফিফটি-ফোর
54.
চলো, এটা করেছে। কবে করেছে? 1/7/14 ও কবে পেয়েছে স্কেল?
পরে এসছে।
একটু দেখে নিতে হবে। To be candid, my lord, both of us had missed this in the list, so we are not thorough with that. But my lord, in light of that order of the honorable coordinate bench, may I come back with instructions, my lord, that what steps has been taken?
দেবজিৎ কুমার।
এটা করে তো is bound.
Yes, but the order which you are referring at page 54 was passed long prior to the
Yes,
special
my lord,
bench
thereafter,
decision.
my lord,
Where is the special bench decision?
special bench division, my lord, just
So
25.
after the special bench decision, you may not rely upon this judgment
But
because
prior to that, my lord, this order was passed.
maybe
It is especially direction.
now it is to be governed by the special bench decision.
Yes, my lord. My lord, as per the GO, I am entitled. As per the GO, I am entitled, my lord. Several representation are made after that, my lord, no decision was taken, my lord. No decision was taken
No
by that.
decision has been taken.
No, in this matter, in this order. Thereafter, I made a several representation till then. Only orally assurance, my lord, with the approval of the higher authority, we release the aerial due. But till that, nothing has been done. But I last representation was made, my lord, 2025, my lord, page 64. 63, 64.
Oh, you have been granted the postgraduate scale of pay,
Yes, well, now,
only the area amount.
no. Area amount along with the postgraduate pay list. No.
Yes.
I had been paid the higher scale of pay. Paragraph 13 of your representation at page 63.
Yes, my lord. Well, area 2 lakh not been.
I'm asking you that. When I have asked you that whether you have
Lord,
been
yes,
granted
my lord,
postgraduate,
Lord.
you said no.
Yes, my lord. That is release, my lord. But area is due, my lord.
That is
Lord,
what, yes, Mr. Bhattacharya, if the scale has been
57,
granted,
yes.
area, so you consider this and take a
Yes.
decision.
Page 57,
Because
I
it's
made.
not that
page
whether he will be,
57, I made the bill, my lord.
I asked you that, you said no. postgraduate scale of pay.
I'm
is to
sorry,
be
my
given.
lord, I missed this in the list. I could not assist your lordship, my lord.
Ashwin.
61 might depend.
The primary grievance of the petitioner is that though the postgraduate scale of pay has been granted in favor of the petitioner, but the arrears has not yet been disbursed in favor of the petitioner. So the petitioner claims to have submitted several representations before the respondent authorities, praying for releasing the area payment of higher scale since November 1999 to October 2014. Full stop. The learned advocate appearing for the petitioner submits that in spite of receipt of several representations, no decision has been communicated by the respondent authorities till date. Full stop. Mr. Bhattacharya, learned additional government pleader submits that the decision on the representation dated
Last mail was 17 December
17th
2025.
of December 2025 shall be communicated to the petitioner within the time limit as may be fixed by this court. First, a paragraph without entering into the merits of the claim made by the petitioner in the representation dated 17th of December 2025, WPA number stands disposed of by directing the
Respondent number 3. Third respondent.
respondent number
Third. District Inspector of School, Secondary Education, Kuchbihar.
by directing the District Inspector of Schools within bracket AC Kuchbihar being the third respondent to consider the representation of the petitioner dated 17th of December 2025 and to dispose of the same by passing a reasoned order after affording an opportunity of hearing to the petitioner which shall be communicated to the petitioner immediately thereafter. First of the entire exercise shall be completed by the aforesaid respondent as expeditiously as possible, but positively within a period of 6 weeks from the receipt of a server copy of this order together with a copy of the representation dated 17/12/2025. First up, at the hearing, it will be open to the petitioner to place reliance upon any government orders, circulars, orders passed by the court in support of his claim. Yes.
Number 9.
Lordship, in this item, I'm made by Mr. Bhutan Bhattacharya appearing to please.
My lord, I'm
Yes,
happy.
Mr. Bhattacharya.
My lord. My lord, very
Yes.
innocuous here. Here, what has happened, the adjudication order has been passed without giving me any notice, or rather, without giving me any opportunity of being heard. Why I say so? My lord, there were two adjournments. First, the adjournment notice was never uploaded. I did not know the date. The second adjournment was also granted suo motu. Both the adjournments were suo motu. Second adjournment dated it on 11/2025. But the order was passed on 3rd December 2025. Now, my lord, my humble submission is I have missed the dates because of uploading in the wrong tab. Additional notice tab they are uploaded. Now, if they were supposed to pass the order on 3rd of December, not on 18th, they could have given me well another opportunity. And all these were uploaded in the additional notice tab. Now, my lord, why I say additional notice tab, lordship will kindly come to my view notices tab screenshot, page 61 and 63. Here in this screenshot, now
Page,
they have
page.
marked it, 61 and 63. Lordship will see all these notices.
18/11.
Yes,
When the order was passed,
my lord, the
where is
order
the
was passed
adjudication
on
order?
page 50. It was passed on 3rd of December. Last page of the adjudication order will speak for itself. Page 54 will show the date. It starts from 50.
Page
54 will show the date.
54.
My lord, the last page of the adjudication order, that will show the date. 54, my lord.
Five.
4. left hand side, my lord, 3/12/2025.
Left. 3/12/2025.
Yes. Why?
This is an order passed under section 7. This is an order passed under section 73.
My lord, 73.
Yes, Mr. Mr. What do you say?
My
61.
lord, yes, Mr. to speak in the mic. I cannot hear.
Mr. Please speak through the mic.
Yes, Lord. This is the dashboard that the petitioner himself has provided along with the writ petition. Under the simple view notices and order, the case details is there. When
No,
you
that
click
is
on the
what, that
notices,
is what,
notes,
my lord, that is what I wanted to say. This is after the amalgamation, and all these notices are viewable after the amalgamation. Before amalgamation, the amalgamation happened in February 2026. I cannot get the screenshot before that. Now, these are visible only after amalgamation, and that is what I have shown. And Lordship will see at page 63, the second.
No, this adjournment notice was at their instance. They have so moto adjourned it.
Yes, suo motu adjournment. NA. Lordship sees the notice was also not uploaded.
Where have you pleaded that? Where have you pleaded that?
Yes, I have pleaded that.
Which paragraph you have pleaded?
My lord.
not at page 61, the table that they have provided, not the personal hearing is yes. And even in case of the second adjournment, the personal hearing is yes. So therefore, a
Yes.
report has to be called for. A report from the
Paragraph
revenue authorities has to be called.
Paragraph 5.
If you
And
want, Mr.
paragraph
Mishra, I
7.
can direct. But only one thing,
Give us 1 week time, my lords. We will come up with
they
a
are
No, this
saying
can
that
be-
it is, this
It
is
can be sent back to
after
the-
the merger, this.
I understand that, but you're here in the date of the IP and date and the IP address is not there, so we need to ascertain the fact. Had it been a case of personal hearing, no and no, then obviously we
No, the date
you
is there.
won't have
The
many
date is there, my
many
lord.
things to say before, my
The
lords.
date is there. The date is there. Lordship will kindly see.
Now, whenever an entry yes is made, there has to be some document that is with the revenue authority. Therefore, a yes has been endorsed there.
All right.
Report call for next circuit.
Lord, I only humbly submit this, that since this matter can be very well adjudicated by the adjudicating authority and no harm will be done to the respondent, let a time-bound adjudication be fixed. Because there is no point.
No,
in
everything
all this
revolves around the
matter.
natural justice violation. So if yes is there, we need an opportunity.
Mr.
No,
Bhattacharya, if they want
admitted-
time,
No,
he has
my
to
lord,
give us some time to take instructions.
Yes.
My lord, only,
Because
only
we have
my-
pleaded some
my
facts,
sug-
let
my
him take
suggestion.
instructions on that.
My only humble submission and suggestion, my learned friend can also consider, the only point is, another point.
No, Mr.
that is
Mishra has,
undisputed.
Mr. Bhattacharya, I tell you, Mr. Mishra has not disputed in other matters, but with
Yes.
regard to this.
Because the yes is there in the
Yes,
personal
yes,
hearing.
because with regard to something, this adjournment, let him take instructions.
My lordship.
My lord, only, yes, Lordship, only one thing, that is the last date
You want
of
to file a
adjournment
report or you
was
want to come back with the
18th
instructions?
November.
I will come up with an instruction based upon what documents, not the personal hearing yes column has been filled up here at 2 occasions in that adjournment.
Heard Mr. Bhattacharya, learned advocate for the petitioner, Mr. Mishra, learned assistant additional advocate general, prays for an accommodation to revert back with necessary instructions. List this matter under the same heading before the next available.
I'm not.
Lordship, I am appearing
My
for the
lordship,
CGST lordship in this case.
Yes. 10 years.
In Lord, I'm the petitioner. I'm led by Mr. Arnab Shah. He's appearing in the virtual meeting.
I may be allowed to.
I'm for the state.
Also, the issue is this, Lordship, the petitioner. Lordship, the petitioner is a owner and possessor of a particular plot of land by virtue of a law of inheritance, inherited from his father, and parallelly by virtue of a deed of gift that I have annexed. Now the issue is that, Lordship, my plot of land is surrounded by four strip of land which is owned by the Refugee Rehabilitation Department. Now the Refugee Rehabilitation Department has given patta to the respondent number, given formally patta by issuing deed of gift in favor of the respondent number 13 and 14, which I have no, where I have no issue. And but respondent number 12 has somehow managed to get their name recorded in the record of right. And similarly, the respondent number 9, 10, and 11 also managed to get their name in the record of right, and they are in occupation. I don't know whether their occupation is lawful or not. The issue here is this: one plot of land which has been is a public road that has been demonstrated in the record of right, which is owned by the rehabilitation department, which I access to this road. I reach to my property. Now this road has been encroached by making construction by the private respondent, which compel me to come before your lordship, because I have earlier approached with the concerned authority with the legal notice, but the said authority are silent about the matter, and thereby they are allowing the impune construction over the public road. This is the point of grievance, lordship, that to be redressed according to the terms of the West Bengal Panchayat Act 19, the provision of section lordship 120 sorry lordship, sorry 23 within bracket 5 of the West Bengal Panchayat Act and 114A and 114B5 of the West Bengal Panchayat Amendment Act 2017. Any unauthorized construction, if made, the primary duty is on the concerned panchayat to take necessary action. The panchayat is sitting tight over the matter despite making a formal complaint to this encroachment of the public road. I strongly believe that all the impune construction is absolutely unauthorized, because there should not have any sanction. I am not to disturb with the other lawful position or purported lawful position or not, but I am only concerned with the encroachment of the public road. Section 23(5).
Yes, Mr. Bhattacharyya, what do you say?
My lord, his primary grievance from the representation seems to be against the panchayat. We have sought for instruction from the subdivisional officer as well. We are yet to get the
Because
instruction.
if it is a public land,
Yes, my
what
lord.
it says that it is recorded in the name of the Refugee Rehabilitation Department.
Yes.
So he might have said that his panchayat is doing that without sanction. That
Is what, my lord,
But
we
the encroachment upon the public land, it's the duty of the SDO to
SDO.
look into it under the 1962 Act.
yes.
Exactly. Great.
We have sought for instructions, my lord.
So,
Kindly.
meanwhile,
the representation has been submitted against to the SDO.
Yes. All.
Yes.
Page number 62.
Page 62.
The eighth address at page 62.
3.
In the
Page
meanwhile,
62, the eighth address, my lord.
Subdivisional officer.
Yes.
So
Sadar
let a
Jalpaiguri.
subdivisional officer look into it.
My lord.
If if there is any encroachment of the public land, he will take steps under the 62 Act.
Yes, my lord.
If not, he will refer it to the authorities, and if no encroachment, you communicate the decision to
my lord. Grateful. Meanwhile, the impune construction may be stalled. Meanwhile, the impune construction may be stalled.
Let them construct, it will be demolished, let them invest something.
That will be
public land.
Let
the public land be improved. When it will be demolished, everything will be demolished.
My lord.
Let there be some improvement on the public land in the meantime.
Private respondents are also not here.
Private respondents have to serve.
Yes, all have been served.
Service.
Evidence service filed in court today is taken on record. The learned advocate appealing for the petitioner submits that the private respondents have been duly served. To stop, however, none appears for the private respondent. State is none appears for the private. Panchayat is also a party.
Yes.
Yes.
Respondent number 6 and 7.
Respondents.
6 and 7.
and the Panchayat authority will duly served. However, none appears for the private respondent and the Panchayat authority. State is, however, represented by Mr. Bhattacharya, learned additional government leader. So, the petitioner claims to be the owner of a plot of land. The grievance of the petitioner is that adjoining the plot of the petitioner, there is a public land, and the private respondent has raised a construction, have raised constructions by encroaching upon the public land, thereby creating obstruction to the ingress and egress of the petitioner from his property to the main road. So, the petitioner submitted a representation before various authorities, including the
Respondent number 8.
My lord, subdivisional officer, Shodor, Jalpaiguri.
what is the date?
My lord, 21st of May, on the left-hand side of, at page 62, top left-hand side.
The petitioner submitted a representation dated May 21, 2026 before various authorities, including the subdivision officer Shodor, Jalpaiguri, SDO Shodor office, Jalpaiguri,
Respondent number
requesting
8.
the same authority to
Respondent
remove
number
the
6.
encroachment from the public land. First paragraph, since an allegation of encroachment upon the public land has been made, it is the duty of the respondent authority to take steps in accordance with law. First paragraph, without entering into the merits of the claim made by the petitioner in the representation dated May 21, 2026, WPA number such and such stands disposed of by directing the subdivisional officer.
Subdivisional officer with the respondent number 6, my lord.
6.
By directing the subdivisional officer, Shodor Jalpaiguri, being the 6th respondent, to consider the representation of the petitioner dated May 21, 2026, and after causing necessary inspection and inquiry, after causing necessary inspection and demarcation of the disputed plot by engaging competent amins/surveyors upon prior service of notice to the petitioner, the private respondents, and any other person who may be affected by such demarcation. And upon such demarcation, if it is found that the public land or any portion thereof has been encroached upon, proceeding in accordance with the relevant statute shall be initiated, and the entire exercise shall be completed by the said respondent as expeditiously as possible, but positively within a period of 10 weeks from the receipt of a server copy of this order, together with a copy of the representation dated May 21, 2026. So, upon such, if the state respondent authority arrives at a conclusion that there has been no encroachment upon the public land, such decision shall also be communicated to the petitioner and others within the time limit indicated hereinbefore. So, if, however, the said respondent is of the view that the issue relating to encroachment of alleged demarcation do not fall within its jurisdiction, such decision shall also be communicated to the petitioner within the time limit mentioned hereinbefore, and in that event, it will be open to the petitioner to work out his remedies in accordance. Yes, next. Yes, next.
Item number 11.
My lord, I'm appealing for the state, my lord.
Yes.
I'm appealing on behalf of the petitioner in this matter, your lordship.
Yes.
Instruction to.
This matter pertains to transfer of the petitioner, your lordship, But here the order of transfer was passed, Your Lordship, on 13th of March 2026. Subsequent to that, Your Lordship, the assembly election was declared. So the petitioner made a representation with a prayer to extend the time to join the state's transfer school, Your Lordship, because there was a time limit for 15 days within which she had to join. Depending on that representation, the chairman, Jalpaiguri DPSC, extended that till 10th of May 2026. Post-election, that was done by the chairman. Subsequently, when the petitioner went to join her transfer school, the SI of the concerned circle, Your Lordship, denied to allow her release order. Hence, she made another representation.
Release order from the earlier school.
Release order from the SI of the earlier circle, Your Lordship. So she could not gather that document, so she could not join the state school, and the time span of 10th of May exceeded, Your Lordship. So she made a representation within time that you extend my time, because the SI is not allowing me, verbally asking me that that would not be passed because there is a direction, but there is no written communication from the end of the SI, Your Lordship. Subsequently, she sent a legal notice stating that this is the situation, kindly consider, because I had obtained the order of transfer on 13th of March.
You have now got the release order.
No, I have not got the release order, and they have not complied with their order of 13th
Yes,
of...
who is appealing for this? Yes, Mr. Ghosh, you are appealing for.
But I am for the board. The DPSC is the answering
Not for the
respondent.
Yes, yes. What is your instruction?
Sir, the instruction is here. Your Lordship. And as for the transfer, sir, the medical board has to clear. She has to clear the medical board requirements because the
Once
transfer
the
was
transfer order was passed, order of transfer was passed.
addressing authority was not there. She should have addressed the secretary, not the chairperson.
No.
Secretary is the main answering respondent, sir, of the PSC.
Secretary of the DPSC.
Yes, Your Lordship.
Who is appearing for the DPSC?
Yes, my lord.
Yes. What is your submission?
I'm being late by Mr. Ram.
Yes.
Lordship, at present, Lordship knows that after the change of dispensation, the chairman resigned. Now the DI is acting ex officio as the chairman. So the DI is represented by the state government now. They can answer.
May I, Your Lordship, may I assist the court, Your
No,
Lordship?
no. Yeah, but it's a question you are functioning with what post? That's neither here. The man is not important. The post is important.
Now,
When you are performing the dual post, you have to answer for that post.
Lordship, we have already given it, and they went also. They went to join also.
Yes, now she is not being allowed to join. Now can you reopen your own order of transfer? That is exactly what you are trying to do.
Your Lordship, the instruction said that the petitioner applied for
Madam,
general
instructions may be
transfer.
there. How can you recall your own order? No.
No, the application was not treated on the medical ground.
It is on
Can you
Because
recall your
it
own
should
order? Madam, how can you recall your own order? Where is the provision to recall that? Yes, Mr. Vadayaji.
There is not, my lord. Well, Lordship, kindly takes it tomorrow. I'll.
Yes.
Your Lordship,
Mr. Vadayaji, please look into
Yes,
it.
yes,
You
yes,
cannot-
definitely.
if,
Definitely.
Rightly or wrongly, that order was passed. You cannot now
No,
reopen
no,
that.
we cannot decide on that. Kindly takes it tomorrow. my lord.
Yes. Mr. Vadayaji, when this matter is taken up for hearing, Mr. Vadayaji, learned additional government leader appears and prays for a day's accommodation. First of this matter tomorrow, or to enable Mr. Vadayaji to revert back to this.
deeply obliged, Your Lordship.
Yes. Next.
About Dhaka.
Similar issue, Your Lordship, the order of the 13th of March 2026, Your Lordship, subsequently he was denied to join his school, Your
Yes,
Lordship.
who is appearing?
My lords.
Madam, you are appearing for the state
Yes, my lords. My
Yes.
lords, we have not received the instructions yet.
tomorrow
Grateful, my lords.
on the prayer of the learned advocate for the state, my lord, tomorrow. Yes, next.
13th similar prayer, your lordship, because of the order of 13th of March 2026, your lordship.
13 is also same.
Same, your
Same matter.
lordship.
You are appearing.
Yes, ma'am.
13 same order next. 14.
Similar prayer, your
My lord, I
lordship.
am for the
14 is also that.
Lordship.
14
My
is
lord, we
appearing for
need-
the state
I am for the state, my lord. We need some instruction, my lord.
tomorrow.
Grateful, your lordship.
Yes, next.
Yes, my lord.
15, my lord, I am for the petitioner and I am praying for interest of gratuity and ADR pension, single PPO. My lord, this is the affidavit of service and my lord order corrected on.
Yes, disposed of next.
Grateful, my lord.
My lord, I am for the petitioner lordship.
Yes.
Well, this is a matter where my lord, the petitioner superannuated as principal from the Ananda Chandra Training College, Jalpaiguri.
Now what is
But-
your problem now?
Problem, he is not getting pension on the ground of pendency of the criminal case. My lord, that cannot be, your lordship knows, my lord, better than me, lordship. There are the several judgments of the
Provisional
honorable-
pension you have got.
Provisional pension I have not yet got, my lord. My lord, the pendant, my lord,
No, no,
the
no.
act, my lord, by which the college is
এটাও তো ভুল
guided.
ফাইল দাঁড়ান এটাও ভুল ফাইল দিয়েছেন ওটাও নয় দেখুন শুভেন্দু বিকাশ মোদক এইটাই
My lord, the act by which the college is guided, here is nothing, my lord, with regard to the, my lord, not disbursing the pension because of the pendency of the criminal case or departmental proceeding. Even if your lordships kindly see the DCRB rules, lordship, your lordship will see if the person is convicted or he has been penalized by the departmental proceeding, then
Yes,
only.
what is your instruction?
No, Lordship, we have not received the instruction, Lordship. Lordship kindly sees the page number 22, Lordship. He has
22.
prayed for the release of the pension on 3rd July, Lordship. And today we
3rd
are-
July?
3rd July.
No, lordship, before that, lordship kindly comes to page 21. His all documents has been sent by the
Lordship,
president
7th
of the
July.
president
Receipt-
governing body of the Ananda Chandra Training College on 25/6/2025.
Lordship kindly sees the endorsement, Lordship, 7th July, Lordship. And today we are on 24th. of-
My lord, and he has been
7
superannuated.
July 2025
My lord, he has been superannuated.
1 year you have fallen in your own trap.
My lord, the similar order has been passed by the honorable coordinate bench. My
Lordship,
lord, my lord, even in spite of my lord pendency of the criminal case, lordship, my lord pension is a my lord right of the property under my lord 300A of the Constitution of India that cannot be withheld on the ground of pendency of the criminal case, lordship.
Lordship, let the instruction come, Lordship.
My lord, what instruction, lordship, in this matter? Even the DCRB rule says after conviction, pension can be withheld.
Misapplication of some of a
No, that is with regard to that person.
here
My lord, here, my lord, the allegations of, my lord, the colleague of, my lord, under section 354 of the Indian Penal Code, that case is pending since 2014. The next date is December 2027 for service return. So, my lord, the de facto is even not interested, my lord, to proceed with the criminal case. It's a completely false criminal case. However, lordship, I am not on that. My lord, my submissions before your lordship, my lord, the pension cannot be withheld for that, my lord. My lord, this particular petitioner, my lord, he was the principal, my lord. He, my lord,
what is the charge against you?
my lord, the lordship kindly comes to page
disciplinary proceedings initiated during your service.
No, my lord, no disciplinary proceeding as yet.
No disciplinary
No,
proceedings.
lordship. Lordship charge, lordship kindly comes to page 25. Is the information slip of the disciplinary proceeding. That is 354A, 354D, 34 of the Indian Penal Code. And if your lordships kindly comes to page 26, lordship will get the next date of hearing, the bottom portion of that page, 7th December 2027 for SR and appearance. The case has been initiated in the year 2014.
Yes, madam, how can you
Lordship,
withhold the entire
We need
pension?
some time, Lordship.
My lord, my humble submissions, let the my lord, the matter may be sent to the authority concerned for my lord
Consideration.
And lordship kindly see the order, my lord, the earlier order. Because he is entitled, lordship.
Madam,
My lord,
please don't
know.
allow me to
My
give
lord, my
any,
lord.
in that matter, there was a complaint by the college authorities with regard to misappropriation.
Yes, your
of
lordship.
funds, college
Yes, lord.
funds.
Yes, my lord,
So please,
kindly
I
consider
have-
that that is my
madam, I
lord
have
more
certain reservations with regard to the judgment which you have shown.
reserved. My lord, in my case, that is not my
Because that's a loss to the college
college
authorities.
fund,
Even
college fund.
that,
My lord,
reserve.
in my case, that is not the my lord, the charges, my lord.
because provisional pension is one thing.
Provisional
Full
he will get.
So provisional pension may be one thing, entire pension and other things, there may be certain things.
My lord, that
If you
cannot
want
be lost.
consideration, I can direct that. And if you want the matter to be decided, have to call for that report or affidavits, whatever you want.
My lord, affidavits, it will take. He
I'm
is in a
directing
very
them to
situation.
consider this,
Yes, my lord.
allowing you to raise all points before the authority.
Yes, my lord, because my lord, he's suffering from brain attack, my lord. I have annexed all the documents, my lord, the affidavits, my lord. Maybe, my lord, some other.
The petitioner, when the complaint was lodged during your tenure of
Yes,
service,
yes. 2014 lordship will get that.
2014,
Yes.
and you retired on
My lord, he has been retired on 31st 12/2025.
the petitioner retired. No, the petitioner, who was the principal of a college, retired from his service on superannuation on and from 31st of December 2025. Full stop. The the grievance of the petitioner is that till date, the pension and other retirement benefits has not been disbursed in favor of the petitioner. Till date, police. The learned advocate appearing for the petitioner, submits that during the service tenure of the petitioner, a colleague of the petitioner lodged a complaint which gave rise to registration of an FIR being Jalpaiguri Police Station case number 78 of 2014, dated 15/11/2014, under sections 354 capital A, 354 capital D, and 34 of the Indian Penal Code. First of the said case is still pending before the learned magistrate second court at Jalpaiguri and is at the stage of service returns and appearance. First up, the learned advocate appearing for the petitioner submits that pendency of the criminal case cannot be a bar, cannot be an embargo in releasing the pensionary and pension and other retirement benefits in favor of the petitioner. First up, she places reliance upon an order dated 10th of April 2023, passed by a coordinate bench in WPA 484 of 2023 in the case of Sri Sunil Kumar Jana versus State of West Bengal and others.
This is a case of Honorable Apex Court, my lord, where Honorable Court says, my lord, the pendency of the departmental proceeding or the criminal proceeding will not, my lord, the reason for withholding the pension, my lord.
She also refers to a decision of the Honorable Supreme Court, case of State of Jharkhand and others versus Jitendra Kumar Srivastava and another, reported at AIR 2013 SC 3383 in support of his contention. That pension cannot be withheld on the ground of pendency of a criminal case. Full stop. The learned advocate appearing for the petitioner submits that the respondent authorities be directed to communicate their decision on the representation submitted, representation dated
My lord, representation dated lordship 2/7/2026.
2nd of July,
page
representation
22.
dated 2nd of July 2026. Submitted before the Director of Public Instructions within bracket pension. First up, Ms. Singh, learned advocate appearing for the Ms. Singh, the learned junior government advocate, submits that the decision on such representation shall be communicated to the petitioner within the time limit that may be fixed by this court. First up, paragraph, without entering into the merits of the claim made by the petitioner in the representation dated 2nd of July 2026, WPN number such and such, and disposed of by directing the Director of Public Instructions within bracket pension to consider the representation of the petitioner dated 2nd of July 2026 and to dispose of the same by passing a recent order after affording an opportunity of hearing to the petitioner.
On the representative of the petitioner.
After affording an opportunity of hearing to the petitioner or his authorized representative and communicate the recent order to the petitioner as expeditiously as possible, but positively within a period of 4 weeks from the receipt of a server copy of this order together with a copy of the representation dated 2nd of July 2026. So it is however made clear that it will be open to the petitioner to place reliance upon the relevant provisions of the statute, government orders, orders passed by the court in support of our contention, and if and the respondent authority shall consider the same while passing the recent order.
I'm grateful. Your Lord.
Consider and deal with the same while passing the recent order.
Grateful. Your Lord. Next.
Yes, next.
Junior government leader, however, not advocate
Yes.
in the body. Daily.
Yes, Mr. Ghosh. What is the date you have mentioned in the communication letter?
29th, Lord.
Then, in all matters, Mr.
Milord,
Ghosh, why?
there's a difficulty. I found out that the department is taking approximately 2 working days to give the filing number. The registration number is given immediately. 1 or 2 days they are taking for screening the petitions, whether there are any defects or
Then you have
pages
to
are
give,
legible.
accordingly, you have to give the date of enlistment.
So that Milord, we
This
have
thing you are
to,
appearing for the state.
Yes, Lordship.
this Milord, we have to modify also, Milord, from our side also.
Yes, because in all matters, if the state do not appear, you cannot fault with them.
There's a lag of 1 or 2 days which is happening,
Yes,
Milord, in between the
because
returnable
they
date
might
and the
miss.
date.
And
Milord,
it's
unless we
difficult
give
to go through all the affidavit of service. You say, yes, it has been served. We pass orders on the basis of that. Now, if they come and say, no, we have not been served, the date is.
This is, Milord, the prayer is quite innocuous. Milord, I
I
tell
have
you,
the
Lordship.
instruction, Lordship. I have
Milord,
the
what
You have
has,
got the instruction. Yes,
Milord, what
is
has happened here, Milord, is the petitioner applied along with others for a FPS dealership. Now, Milord, in the initial round, when this screening and appointment was conducted, the petitioner was not eligible. His candidature was rejected. But the person who was appointed, it transpired that one of his direct relatives is also holding a FPS dealership. Petitioner preferred a complaint. There was inaction. First round of litigation before this court. The coordinate bench sent for a hearing and a decision. That decision transpires from that decision, the reasoned order which was passed, it transpires that the allegations were correct. Second round of writ petition, this honorable court directed cancellation of the candidature of the person who was selected. Now, once that person was eliminated, I made a representation that since the person who was earlier selected is now ineligible in view of the judgment passed by the honorable court, my candidature, and if there are other applicants who had originally applied, kindly consider our candidature amongst us, who if someone is found eligible, kindly appoint. We have made a representation. We are only praying, Milord, that representation be considered along with me, the other candidates who had initially.
Can it be done in that way, or a fresh selection process is to be initiated, Mr. Ghosh?
Milord, the rules are not clear on that.
You have the copy of the rules, because
Milord,
once a selection has been made,
yes,
the panel.
Well, let them decide. If they feel that no, they cannot be considered, a fresh advertisement has to be made, let them, Milord, pass a reason this
What is
order
the
to that
instruction?
effect.
Yes, Lordship, because the scrutiny is going through, Lordship. Even this, we have received the papers of the Jeevan Burman, this petitioner, Lordship, and other applicants, Lordship. So it will take some time to scrutiny of all these documents.
Milord, there is no part in the rules. Because the rule
Because the
says when a vacancy
earlier-
arises.
Earlier notification was
Yes, so-
set aside by the.
So when a vacancy arises, the process is to be, that process is to be followed. Now, a selection process was initiated. A person was selected.
Yes.
Now, when that selection is cancelled, again a vacancy arises.
But the selection process has not been abandoned in total.
There is nothing.
There's only one
when
candidate.
appointment has
No,
been
Milord,
given,
even-
what remains in the selection process, Mr.
Milord, the other candidates are there.
Cannot be done.
Milord, for example, Milord,
Cannot be done.
for petroleum retail outlets, Milord, when a person, even if selected, if subsequently found ineligible, amongst the other candidates, they select a candidate.
Where is your representation?
Milord, at page 66, 3rd July 2026. Here, Milord, the first eligible candidate was somehow found ineligible. So, Milord, accordingly, Milord, the other candidates, they can be considered.
Yes, take a decision on this.
Lordship.
The petitioner claims to have participated in the selection process for appointment of a fair price shop within bracket FPS capitals bracket close dealership for the locality of Nolgram fragment pursuant to a vacancy notification issued by the Food and Supplies Department, Matabanga, on 15th of February 2022. System. The petitioner, along with others, participated in the said selection process, and one Vishnupada Odhikari was selected and was appointed as an FPS dealer. Subsequently, the appointment of the said Vishnu Podo Adhikari was set aside pursuant to an order.
Yes,
Pursuant to an order.
Pursuant to an order passed by a coordinate bench. Full stop.
But page 47 is the order.
The petitioner thereafter submitted a representation dated 3rd of July 2026 requesting the authorities to consider the candidature of the petitioners for grant of FPS license for the locality of Nolgram fragment upon the cancellation of appointment of the said Vishnu Podo Adhikari. Full stop. Mr. Ghosh, learned advocate, appearing for the petitioner, submits that since the petitioner along with others participated, since the petitioner, Vishnu Podo Adhikari along with others participated in the selection process and the selection of the said Vishnu Podo Adhikari has been set aside, the authority should be directed to consider the candidature of the petitioner and other candidates excepting Vishnu Podo Adhikari for the purpose of appointment of a fair price shop dealership for the locality of Nolgram fragment. He submits that in spite of a representation being submitted by the petitioner, no decision on such representation has been communicated to the petitioner till date. So Ms. Singh, learned advocate, Ms. Singh, learned additional junior government advocate, submits that
Scrutiny of the documents is under process. Scrutiny of the documents of the petitioner and the other applicants is under process, Lordship.
I will record that.
On instructions, Millet.
If you want that, madam, I can record that.
You're on instructions, no difficulty in recording.
But in Lordship, leave it, Lordship.
So the hurdle, Millet, the hurdle your lordship has posed has been already overcome. Millet, can you record this on instructions?
You have received
Lordship, in
instructions.
instruction, there is other thing also,
Millet,
Lordship.
there is a written instruction, I
Yes,
can
Lordship.
see.
He's Lordship, off the record, Lordship, kindly don't record, Lordship, his candidature already, Lordship, he fails. His document has already rejected.
That is a different question, but it should be
This
considered.
document has been rejected.
Yes, Lordship. We will communicate, Lordship, but don't record, Lordship, in this petition. This is subsequent cause of action, Lordship.
Ms. Singh, learned government advocate, submits that the authorities, that the prayer of the petitioner as ventilated through the representation dated July 3, 2026 is under consideration by the respondent authorities, and the decision on such representation shall be communicated to the petitioner in due course. Full stop paragraph. Without entering into the merits of the claim made by the petitioner in the representation dated July 3, 2026, WPA number such and such stands disposed of by directing the subdivisional controller, Food and Supplies Department, Mathabanga, being the fifth respondent, to consider the representation of the petitioner dated 3rd of July 2026 and to dispose of the same by passing a reasoned order after affording an opportunity of hearing to the petitioner, any person who may be affected by such decision or their authorized representative, and communicate the reasoned order to the petitioner and others as expeditiously as possible, but positively within a period of 6 weeks from the receipt of a server copy of this order together with a copy of the representation dated 3rd of July 2026.
Grateful.
Yes, next. Case number 80.
My lord, in this matter, I am appearing for the private respondent, my lord.
आप ready है?
Respondent number 6, my lord, I am.
Respondent number 6.
Also, only
My lord,
not
I am-
today in this matter. No.
Not
My lord, I
today.
am- It
Why,
is not
Mr. Biswa,
maintainable.
you are not
I'm
in a
not,
mood- You are not in a mood to move matters today.
no, no, my lords. How can that be? I have gone through the brief that is there, my lords. There are a couple of things that we need to take instructions upon.
All right, let Mr.
Well,
Ghosh
Let's just place, should I
and
place the
Mr.
facts?
Agarwal
Yes.
justify their appearances.
My lords,
My
we
lord,
will also.
Let's just
only
slightly
not to
unusual
substance
matter.
here,
Yes.
but your lordship,
Well,
I
of-
am taking the
maybe of
point of
some interest
maintainability.
also.
I am taking the point of
Yes,
maintainability
yes.
that
What
it-
is this?
Millard, in the year 2004, Millard, I received an information that 28 kathas of land situated adjacent to my plot is being sold and transferred. I prefer an application before the ADSR seeking to know whether a deed has been executed. I receive information in the year of 2004 on a particular date, a deed has been presented, executed, presented. However, registration process has not been completed. Despite that, Millard, I proceed on to file a application under Millard Section 8 of the WBLR Act. Injunction, Millard, initially was granted, subsequently in appeal vacated. 227 application preferred before this
No, no,
court.
Section 8 preemption.
Preemption.
If the registration is not completed,
I'm
how
coming,
can you
Millard.
file an application for
Millard,
preemption, Mr.
Millard,
Ghosh?
I am coming, Millard. I am coming to that.
Now his
227
prayer is so
application
that the
preferred.
registration gets complete, so that his application would be.
227 application preferred. A reported judgment comes out by Justice P.K. Rai, 2006 4 CHN, which says that until registration is not completed, preemption injunction cannot be granted since there is no prima facie right. SLP preferred before the Supreme Court. Mr. Agarwal's clients make an undertaking that we are not creating any third
He's the
party interest.
PMT.
He's the preemptee. We are not creating any third party interest. So the Honorable Supreme Court records that matter gets over. The preemption proceedings, no application taken out for rejection of the proceeding in limine. The matter proceeds to the preemptory hearing stage. We prefer an application under Order 11 calling for the document for production of the document, that is the deed in question. That application was subsequently rejected. They filed the written objection, another 227 application taken out, which stays alive since 2025, dismissed for non-prosecution. Matter is pending for evidence. Now, Millard, today, my prayer in this writ petition is, Millard, only for a direction upon the ADSR to discharge his statutory functions under Rule 22 and 23 of the registration rules. Rule 22 says, upon being presented on 8 or 9 grounds, he has to satisfy himself. If he is not satisfied, he has to forthwith reject, return the instrument, and make an endorsement in Form 2 of the registrar. Rules are very clear. Well, since 2004, he has failed to discharge this simple statutory function. That is my grievance. Because, Millard, I am still prosecuting, and Millard, I have a right in the registration process. Because, prima facie, Millard, I enjoy the longest common boundary in respect of 28 kathas. That is, Millard, my only prayer in this writ petition. And Rule 22, one of the grounds is whether the instrument is duly stamped.
The registration act.
Millard, I have a book, Millard, but I have only one copy. Millard, I'll place it for your lordship's consideration. 21B, and Millard would consider 22 of the West Bengal registration rules. And it has not, I tell you, Lordship Millard, this has not been registered because they have failed to deposit the stamp duty which was assessed at that point of time, 2004.
Have you annexed the preemption application here?
My lord, the application is not annexed, my lord, the order sheets are annexed. And I have a copy of the application, my lord, I'm carrying it, so it is not annexed. My lord, on 7th July, when we receive an information that they are surreptitiously trying to deposit the court fees, we served a legal notice that you cannot accept the court stamp duty now.
Now, Mr. Mishra, what is your instruction?
My lord,
Or if you want to come back with the instructions, because you were paying for time, if you want to come back with the instructions, I can give you a time.
No, my lords, the instructions are there, it's just that I haven't gone through it. If I can have my lordship for a moment on page 43 first.
20?
4343.
43.
There is the order that has been passed by the Honorable Court below. I will explain us what the situation today is.
No, I will come to that. What is your instruction with
My
regard to this
instruction, my
registration?
lord, is that since 2004 to 2026, almost 22 years has passed by now. The valuation of property which was there in 2004 is not the current valuation of property. They have to
So
deposit it.
registration completed or not completed?
Not completed.
Not completed.
Admittedly.
So can you keep a document with you?
Exactly.
What is the provision of law?
As on today, they have to pay the enhanced fees that is there.
That's the
Duties
different
and
thing.
fees.
Can you keep
Now
a
it is
document,
between
with you for eternity,
Oh.
expecting that someone will deposit the current registration fees and the stamp duties? What's the position of law?
No, that lords, that is why lords, further instruction in this regard was required as to what different steps the authorities have taken in the meantime, how many times they have been intimated, what their reply had been, that needs to be brought on record.
See,
As on today, there is a one page that we have received which says
No, if you
that-
want, because that is
Miller,
an issue, Mr.
Miller,
Mishra,
may I
it's
just-
a legal issue.
Miller, may I just
Because
interject,
if a
Miller?
document is presented, now your duty is either to register it or to communicate the reasons if you do not register it. Good, bad, indifferent, the fact that it has not been registered for 22 years.
So no, we cannot be oblivious of the fact that petition and cases amongst the party was also running in the intervening period.
That's neither here
That
nor
is there.
there. You are not concerned with that proceeding.
No, injunction was there.
Injunction restricting you from registering.
No,
No, Miller, there's no
that
injunction.
was not
So that's the inter parties. You are not bound by that order of injunction. The question is, because with regard to the preemption, 226, it cannot be interfered with. Civil proceeding is pending, that will be looked into in that. Here, only the rate is maintainable with regard to whether there is any failure of public duties on your part and whether he has a legal right.
The statutory
These two-
obligation that is
Yes,
there on the
statutory obligation, and if he has any legal right in that. So these two things are to be considered. Now, the question is, a document is being kept pending for registration for 22 years. The question is whether that can be retained with you or your obligation, because there must be some reason for which it was not registered, A, B, C, D. So, under the statute, you have some obligations to perform. Did you perform that obligation? That's the only issue which is to be considered here.
Yes, we need a detailed instruction on that.
But may I
Miller, in
just
my humble
clarify one
submission-
thing,
What
Miller?
we have got today,
Miller,
my lords, is only on the fact that previously, my lords, the property was valued at 32 lakhs. And therefore, the stamp duty thereupon has to be paid. Today, my lords,
The other issue would be that might be taken by Mr. Agarwal, whether you can now challenge, charge.
yes,
at
that is
least.
going to be the another.
Miller,
issue
that is
going to
different, my lord.
So
May-
that-
may I-
Because today, the
That will
property
be the
value,
other
my lords,
issue.
the property
My lord,
value
my
is
humble
1 crore
submission is
8
different, my
lakhs
lord.
So that will be the other
91,769.
issue. So let us not go into that because you have to first take a decision.
Miller, may I just clarify, Miller, just
My
two
lord,
things.
Before my lord,
Miller,
I
in
am taking a
accordance
point of
with Rule
maintainability.
22, Rule 22, Miller, once a document is presented, the registrar has to satisfy himself whether the correct stamp duty has been paid as on the date of presentation. If it is not, the language is forthwith. Forthwith, he has to reject the instrument, make an endorsement in Register 2. Number one. Number two, Miller, as Mr. Mishra says that whether something has been intimated to him or not, Miller, that is irrelevant.
Not to him. He says that
To
something.
the
whether-
executant.
What transpired
To the
within the-
executant, that is, Miller, irrelevant. I say so because, Miller, Section 29, after presentation, if the executant fails to appear for 4 months, the ADSR has a duty to wait for him to come and make the necessary formalities complete,
No,
provided he
this
is
4
satisfied.
months is 4 months is the time limit for presentation from the date of execution.
Correct.
From the date of execution, presentation is within 4 months.
Within 4 months, and another 4 months with permission of the registrar.
Yes.
So communication between the executant and the ADSR today, Millard, is irrelevant.
Let Mr. Mishra, because I think something has to be on record with regard to this. Otherwise,
He can, Millard, I don't know.
My lord,
No.
before my lord, your lordship makes any.
The rules are
may-
very
may my
clear,
It is a
submission.
2004 matter.
rules may be clear, Mr. Ghosh, he has to.
2004
yes.
matter. 2004 matter, my lords.
My lord, may I make my submission, my lord?
Yes.
My lord,
Yes,
what
yes,
is-
yes.
What is, my lord, what is the fundamental and legal right of the petitioner to move this petition, my lord? I am asking myself. My
That
lord,
I
your
could
lordship,
have also, my lords, said.
my lord will appreciate that until there is a legal or fundamental right of a writ petition cannot be maintained, my lord.
Yes.
He is not a party to this the proceeding of a registration. How can he make an application? My lord, I ask myself.
All right, I
What is-
keep the issue of maintainability open. Ashun.
My lord.
Mr. Agarwal, learned advocate, raises an objection as to the maintainability of this writ petition.
Nothing has been
Full stop,
pleaded in the
Mr. Mr. Mistro, learned assistant additional advocate general, prays for an accommodation to revert back with necessary instructions. Full stop, let a report in the form of an affidavit be filed by the ADSR, Jalpaiguri,
Yes,
by the ADSR, Jalpaiguri being the fifth respondent with regard to the allegations contained in this writ petition within on or before August 7.
Millard, kindly, Millard, 2-3 days would be sufficient. Millard, kindly takes it up on Thursday. My respectful submission.
2004
Millard.
record, my lords.
That's why, Millard, how long will this continue? Millard, a short point, whether
Oh,
they
so
have
my
discharged their
information is
statutory-
the records are not available.
It's not a short point. I will have to argue personally, my lord, to go
Uh,
there.
Millard, in that event, Millard, let them not do anything further. They
no,
come
no,
back,
no.
let them not do anything
No.
further.
Mr. Ghosh, till now it has not been.
No, if they surreptitiously accept the
cannot be-
money on a
it has not
valuation
been
of
admitted.
2004,
How can that be said even
you
before
want
a
the
court,
property?
yes. Who is he? Let me put this question now.
no, I have a right, I am a
No, no, what
prosecuting
is
a
your right?
proceeding.
Anybody, my lords,
Mr.
if I was-
Agarwal's client,
Mr. Mistro, what right he has, that will be considered, that's the
Yes, ma'am.
It is
subsequent
not a
thing.
public interest
But Mr.
litigation that he will
Ghosh,
come and.
today,
please
my lords,
don't,
today, my lords, there is no
ask me
established
to
right that
open
he
my
has.
mouth any further, because something will be there for that,
well, I honorably retract.
because
My lord,
if they do something, it will be in your benefit.
Yes.
Then why are you preventing them from?
Millard, I bow down, Millard, I
Then-
retract.
So if they do that.
His right accrues on my inaction.
it is not a public interest
you
litigation
know-
that he will come and ask for any amendments.
On or before 7th of August 2026, upon supplying an advance copy of the report to the learned advocate on record of the petitioner and the
And also
private
to me, ma'am.
respondent.
My lord.
And the private respondent.
My
Full stop, list is better before the next available circuit bench, subject to the convenience of the honorable bench.
My lords.
Quickly apply.
Matter number 90.
Petition. So I'm for the petition.
Yes.
So the petitioner is a very short and involved. The petitioner is an assistant teacher of a particular primary school. During his continuation of his service, the petitioner was elevated in the post of teacher in charge in a particular school. Now, during the course of his enjoyment, post of teacher in charge, on 16th of May, 16th of September 2025, the petitioner was forcefully evicted from his chair without communication of any transfer order or whatsoever. Immediately thereafter, after a long passage of time, a communication was was made to the petitioner whereby he was directed to leave the post and hand over the charge to the other colleague. The petitioner was forcefully evicted from the chair. Petitioner has lodged a complaint before the authority. Simultaneously, a statutory appeal was referred to the respondent number 3 under section 10 of the primary of the section 10 of the rules 20 rules of the I'm telling that rules statutory rule.
What do you want? You want the statutory appeal to be disposed of?
Yes, that is disposed of. That in the meanwhile,
Yes,
post.
yes, Mr. Singh.
Lordship, post
directly
affirmation.
the,
No. Lordship, why
This is for the board.
No. I'm telling Lordship. The post affirmation of this application, Lordship, a development was stopped.
No, the appeal is before the board.
Board. Respondent
Not
number
the
3.
appeal. Yes.
Now
Yes,
the
who
now,
is yes, where is Mr. Ghosh?
Lordship, may I finish? Lordship, may I finish it?
Where is
In the
Mr.
meanwhile,
Ghosh?
post
Primary
file-
Education Board, Mr. Ghosh is appearing.
No, Lordship, issue is not
Where
here.
is Mr. Ghosh?
Issue is not complete, Lordship. Issue is this, Lordship, the pendency of this appeal, Lordship. A petitioner has been transferred from the present school to another school. That communication required to be produced before this court, Lordship. I'm seeking a leave to file a supplementary affidavit to that effect. Lordship, I would.
What document? Transfer, that is the separate
No.
issue.
Post,
That is
no,
the
no.
separate issue.
No, that since the statutory appeal is pending and during pendency another decision has been taken, both the decision to be considered by by this honorable court, and thereafter a necessary order be passed. So that's why I am subsequent.
During the pendency of the appeal, how can the writ court go into the veracity of the appeal?
No, not veracity. I am not touching upon the veracity
All
of
right, on the pair of the learned advocate for the petition, leave is granted to the petitioner to file a supplementary affidavit. Full stop. Let the supplementary affidavit be filed within
1 week. No, 2 weeks.
Within a week.
2 weeks.
Within 2 weeks from date, full stop, petitioner will be at liberty to mention this matter for
Great.
inclusion in the list.
Great.
Affidavit service.
Every service filed in court today is taken on record.
Grateful.
Yes. Coming after 5 minutes. Yes. Yes, call the next matter.
Item number 2, Lordship, I have given the wrong case number in the mentioning slip for correction. So my apology, my lord, please. I have given
Please
the
give the correct number. Yes. Yes.
Now 20.
20, yes.
My lord, this is my petition, your lordship.
Yes.
My lord, two issues involved in the petition, my lord. There are twofold prayers, my lord.
Yes.
First, my lord, is essentially consideration of my Form 6 application pursuant to an unlawful incorrect deletion of my name in the SR exercise. The second prayer, my lord, is essentially directed against a GO, my lord, government order, wherein, my lord, the state of West Bengal, the respondents seek to exclude and stop my food security entitlement, my lord, based on my SIR outcome, my lord. My lords, may kindly take the GO, my lord, the impugned order. It's at page 96. This is an extra P11, my lord. May I read out from the order, my lord? The special intensive, my lords have it?
Yes.
The special intensive revision 2026 of electoral rolls in West Bengal has recently been completed successfully, and final electoral rolls have already been published by the Office of the Chief Electoral Officer, West Bengal. Based on the outcome of SIR 2026, the Food and Supplies Department has decided to undertake verification and deletion. My lords, may kindly note, verification and deletion of those PDS beneficiaries who have been found ineligible on the account of falling under any of the following categories: ASDD, that's absentee, shifted, dead, duplicate, electors in draft list as per the electoral roll published on 16/12/2025. My lords, I fall in this category, my lord, who was subsequently not included via Form 6. This Form 6 application is now pending, my lords, pending consideration. I'll indicate that, my lord. And then 4 other categories. All are these categories, my lords, who are essentially deleted pursuant to the SIR exercise. Now, my lords, may kindly come the para thereafter, my lord. However, beneficiaries who have filed appeals before the SIR tribunal or submitted an application under CAA may continue to remain active till disposal of the appeal or application. So therefore, 2 narrowly defined exception, my lords. I do not admittedly fall within this exception because my case is covered under Form 6, which is pending, my lord. That's not part of the exception. Now, my local ration dealer has told me, my lord, unless I can submit any proof.
You have not preferred any appeal before.
I cannot, my lord, because my lords may kindly appreciate what happened, my lord. Once my Form 6 is considered and decided against me for inclusion, then there an appeal lies, my lord. I'll just indicate, my lord, because this procedure was special procedure laid down by the Honorable Supreme Court, my lord. I'll just indicate, my lord. May I hand over a copy of that order, my lord? The other Supreme Court order. This one. My lords.
Yes.
My lords, may kindly take para 9 of this order, my lord. This is the order by which Honorable Supreme Court laid down the appeal procedure, my lord. My lords, have para 9?
Yes.
During the course of the hearing, learned senior counsel on behalf of the petitioner have pointed out 2 important issues. Number 1, mechanism of appeal by those persons whose claim for inclusion in voter list has been rejected by the judicial officer. And number 2, the publication of supplementary list, such and such. That's not important, my lord. We are concerned with number 1, my lord. Thereafter, in para 10, my lord, as regards the first issue, namely provision of appeal, our order dated such and such, in no uncertain term points out that the orders passed by the judicial officer will not be subjected to appeal before any executive or administrative officer. That being so, the Honorable Chief Justice of the High Court at Calcutta may request some former Chief Justices and the former judges of Calcutta High Court, preferably the High Court at Calcutta or the neighboring states, who shall be notified, such and such. My lord, I'm not troubling your lordship with the details of the... So therefore, my lords, once my appeal is, essentially my application for inclusion is decided, my lord, thereafter an appeal lies. And it had to be, my lord. So there are multiple categories in the SIR process, my lord knows. The categories which were under adjudication went before the judicial officer. Mine is a case which was deleted at the final roll itself. The roll published on 28th of February, my lord. I shall indicate that. However, my lord, I have a case independent of this, my lord. My case is irrespective of SIR outcome. You could not have discontinued my food security entitlement because that is what has been specifically clarified by the Honorable Supreme Court, deciding on the validity and legality of the power of the Election Commission of India under Article 324. My lords, may I just indicate that judgment? Supreme Court judgment.
We never discontinue her ration card, Lordship.
My lords,
It is
I
very
am
active.
apprehending a threat. Should I
I'll record that.
My lords, I am, my lords, may kindly appreciate.
No, if that is recorded, what do you want?
My lords,
For the
for a moment, my lord, let me dissociate myself from this brief, my lord.
no, that's your prayer. Then
I am asking for a quashing of this order, my lord.
So that will be done. Interim prayer.
Interim-
No, let them come out with an
No, my
affidavit.
lord, I'm praying for a stay, my lord. My lords, may kindly see the
I
notification.
record their submission that your stay of what?
That will grant me the necessary relief.
Yes, so that
That-
they are recording, I record their submission.
That will grant
for
me
the
necessary
present-
relief, my lord. But my lords may kindly consider, as an officer of court, I'm making this submission, my lord. For a moment, my lord, let me disassociate myself from the brief, my lord. This issue, my lord,
That will be considered, sir.
my lords, I
At the
understand.
final hearing.
No, I
Let
am,
them-
my lord, what I'm praying, my lords, may hears me for 2 minutes. My lords, this order, if it continues to operate, it will only give rights to multiplicity of the litigations, my lord. What I'm praying in the meantime, let this order be stayed, because ex facie, my lord, this is illegal. Ex facie, let me just place the
Sir,
Honorable
you are
Supreme Court.
interested in your benefits to be extended to you.
My lords, I'm grateful, my
So,
lord.
they are.
I will confirm. I'll bow down, my
So
lord.
you are, this is not a public interest.
No, this is not, my lord. I bow
Not a
down, my
public
lord.
interest litigation.
I bow down.
You are concerned with your
I bow down.
reliefs. So I record their submission. I direct them to come out with their stands by way of a report. That will be considered.
In the meantime, let there be no adverse. And my lord, my Form 6 application may be considered in a time-bound manner, my lord. That's pending before the
That
respondent number
answering
4.
authority is the
Respondent number 4.
Election Commission of India.
That's their
Election
party.
Commission is a party here.
It's, they're a party, my lord. It's
Who is
respondent
appealing
number.
for the Election Commission?
No, I don't know.
ERO is a party, my lord. Electoral registration
No,
officer.
Election Commission, you have to implead the Election Commission.
The
No,
authority,
no,
my
no,
lord,
they
to
are not
decide
the
on my
party.
Form 6 is ERO, my lord, who's respondent number 4. Election Commission of
ERO is
ERO is
functioning
is a
under the
functionary-
directions of the Election Commission.
yes, my lord.
My lords, but
So,
ECI may not be a necessary party subject to what falls from, my lords. I mean,
you take that risk. If at the final hearing they take this point, you take that risk.
my lords, kindly grant me
that's-
leave. I'll amend the cost title. I'll add ECI as a party.
Mm.
Yes, sir, notification.
And I record your submission that
So for the PR is concerned, Lordship,
yes,
he challenged the notification dated 4th June 2026.
yes, 4th June. So he is
That's why the
apprehending that his benefits, food and these benefits may be interrupted. So I record your submission that
we never deactivated, discontinue his ration card. Lordship.
No, not deactivated, my lord. My lords may kindly
He did.
not deactivate.
uninterrupted distribution of our monthly.
My lords,
Yes.
I'm grateful.
So I record their submission.
During pending of
The petitioner has challenged the has challenged the notification dated 4th of June. Notification na order kore din. Has challenged the order dated 4th of June 2026 issued by the Special Secretary within bracket IT and R, all capitals bracket closed, to the Government of West Bengal Food and Supplies Department. Full stop. The learned advocate appealing for the where is your pleading with regard to this apprehension?
My lords may kindly take
para number 15, kindly read the
15.
15. Page 9.
The petitioner alleges that after issuance of the aforesaid order, the petitioner was informed by the local fair price shop dealer that her entitlement is likely to be discontinued unless she could show that an appeal concerning her electoral status was pending before the relevant tribunal / appellate forum. Full stop. Apprehending that the RKSY-I card of the petitioner would be deactivated or deleted, notwithstanding the pendency of Form 6, the petitioner has approached this court with an interim prayer restraining the authorities not to take any coercive or adverse action against the entitlement of the petitioner, against the monthly entitlement of the petitioner with regard to supply of necessities by RKSY-I card. Full stop. The learned advocate appearing for the state, on instructions, submits that there is no basis in the apprehension of the petitioner that such monthly entitlement with regard to supply of necessities under the RKSY-I card would be stopped or interfered with. Full stop.
Sorry to interrupt, my lord. I've seen the written instruction. Instead of recording that, my lord, what the instruction says that it is active. Condition.
No, Mr. Bhattacharya, active is one thing.
Yeah. And card.
Active is one thing. Whether you will be interfering with the supplies, that is the other thing.
That instruction we don't have. The instruction is it is active at this present moment.
Active is another thing.
Yes, I understand, my lord. But what I
showing on paper it's active.
Yes.
Physically will not be distributing.
So
that cannot be done.
If it is active, my lord, card holder is entitled to all the benefits.
So I record your submission. I record your submission that it is active.
Yes.
And I record your submission till that is not deactivated, he is entitled to. I record your submission.
My apprehension is it will be deactivated, my lord. My apprehension is personal.
Natural corollary of this instruction is that since it is active, my lord, the benefits will be given.
My lord,
ওই অ্যাডভোকেটের সাবমিশনটা কি লিখছে? Now, there is no basis in such apprehension of the petitioner as the said card is active as on date. Full stop. On a query of the court as to whether the respondent authorities on a query of the court as to whether the supply of necessities under the said card would be affected or stopped, the learned advocate appearing for the state submits that since the said card is active, the supply of necessities would not be interfered with or stopped. Full stop. Such submission of the learned advocate for the state is placed on record. Full stop paragraph. Yes, where is the Supreme Court judgment which you are relying upon?
This is the ADR, Association for Democratic Reforms. This is the judgment in which Supreme Court, my lord, upheld the validity of the SR exercise. My lord, may I just indicate the relevant paragraphs, my lord?
Yes, there is a recording with regard to this entitlement of, where is that?
My lord, 186F. 186F, my lord, is the conclusion which says that SIR cannot travel beyond electoral purposes. 186F, my lord. That's the conclusion. This is a judgment, my lord, essentially on the issue of scope and remit of the SR exercise, my lord.
No, that is valid. I think, yes.
My lord, this is the running page.
G. I think G, in cases where the commission is not satisfied that the person meets the statutory conditions for inclusion in the electoral roll, it would be incumbent upon it to refer such individual to the competent authority within the commission's determination being confined to electoral process cannot assume finality on the question of citizenship. Any deletion effected on this ground shall therefore remain subject to the outcome of such adjudication by the appropriate authority.
My lords. F is relevant, my lord, and thereafter there is an oral observation, my lord. We usually do not rely on oral observations, but I'm carrying a life law reporting wherein Supreme Court has but they have granted liberty to move high.
The learned advocate appearing for the petitioner places reliance upon a recent decision of the Honorable Supreme Court in the case of Association for Democratic Reforms and Others versus Election Commission of India and others, reported at 2026 SCC Online SC 990. In support of his contention that the in support of his contention that an inquiry in SIR process does not amount to a determination of citizenship in the strict sense, and any action taken pursuant thereto is confined to electoral consequences alone.
I'm grateful. I'm grateful.
Full stop. The Honorable Supreme Court in paragraph 186 within bracket F of Association for Democratic Reforms and Others, held thus. Bole na? Either set out. Paragraph. Where have you stated that your name has been deleted and that's pending? Where is that?
My lords, para 6 onwards, my lord.
Para 6, that was deleted thereafter.
Thereafter, my lords, para 7, my lords.
Para 7, you have applied, submitted an online for inclusion of your name.
My lords.
That's pending.
my lords.
Uh,
Para 8, my lord.
yes, that's pending.
That's pending, my lord. Form 6
The
application.
petitioner states that in the final electoral roll published on February 28, 2026, the petitioner's name was shown under serial number 1202, but was marked as deleted. The petitioner submitted an online Form 6 on April 9, 2026 for inclusion of her name in the electoral roll. The petitioner further alleges that in spite of expiry of 3 months, no final decision on the application submitted by the petitioner under Form 6 has been communicated to the petitioner. Paragraph. The following the deletion of the name of the petitioner in the electoral roll, the petitioner has taken steps for including his or her name in the electoral rolls by filing an application in Form 6. Such application is pending consideration before the concerned authority. It is the stand of the respondent authorities that the RKSY -I card in the name of the petitioner is still active, and taking note of the submission of the learned advocate for the petitioner as recorded supra, this court is inclined to pass an interim order. The respondent authorities shall not take any coercive steps against the petitioner with regard to his his monthly ration entitlement without the leave of this court. Let a report in the form of an affidavit be filed within
2 weeks.
Within 2 weeks from date. Reply thereto, if any, be filed within a week thereafter. The parties will be at liberty to mention this matter for enlistment after the expiry of the period fixed for exchange of affidavits.
My lord, in this case, my lord, Election Commission of India should be party in this
My lords,
case.
grant me liberty.
He is taking that risk.
My lords, grant me. No, my lords.
Lordship.
I grant
My
me liberty, my lords. I shall include.
I told you at the beginning, you
My
said
lords.
it's not a necessary party.
My lords, I grant me liberty, my lords. I'll include election commission. Unnecessary controversy.
On the prayer of the learned advocate for the petitioner, leave is granted to the petitioner to implead the Election Commission of India as a party respondent in this petition. The learned advocate on record is permitted to amend the cause title of this brief petition. The petition is directed to serve a copy of this application upon the Election Commission of India and file an affidavit of service. Amended copy of the petition upon the added respondent and file an affidavit of service on the next day.
I'm great.
The report that they were report in the form of an affidavit be filed by the who has issued this
Instruction to the
Instruction to
Food and Supplies Department.
Subdivision Controller Food and
One, my lord. Respondent number 1.
No, what?
Impugned order, my lords.
District subdivision. Respondent number 3.
my lord.
The impugned order.
Let a report in the form of an affidavit be filed by the subdivisional controller, Food and Supplies, Kuch Bihar Sodor, and the electoral registration officer being the fourth respondent. That is with regard to that Form 6. Yes.
My lord, I'm sorry, I'm interrupting your lordships in quite a few cases, my lord.
No. Mr. Bhattacharya, that the instructions are necessary. There's no difficulty in that. Because the court needs only assistance, Mr. Bhattacharya. That's important. Yes, please take it back. Yes.
My lord, item number 21 and 22, my lord, the affidavit of service is not complete. It was sent to the GTA. The service has been made, but it is not yet delivered. My lord, I'm seeking some adjournment so that it may be served and I can file the affidavit of service.
The learned advocate appearing for the petitioner submits that the service upon the respondents is not yet complete. First, the petitioner is directed to serve a copy of this petition upon the respondents and file an affidavit of service on the next date. Is this matter before the next available? Yes, next.
22 similar.
Same order. Next. 23. Yes.
Item number 23 is similar as item number 11, 12, 13 and 14, your lordship.
11, 12, 13.
13. It's similar because the order dated 13.
Same as 11, 12 and 13.
Instruction awaited, man.
Yes, next.
24.
Same as item 11, your lordship.
Same order.
Good to your lordship.
Next. 25.
My lord, 25 similar orders as 21 and 22. My lord,
21.
service is not yet complete, my lord.
Yes. 21. Same as 21. Service not completed. Yes. Next. 25. 26. Yes.
I represent the de facto complainant victim in this instant case. This writ petition has its roots in a first information report and
Who is for the petitioner?
26.
26, my lord.
26 is not your item. It's mine.
My lord, I have not been made a party to this writ proceedings, my lord. I beg for leave to appear and represent the de facto complainant victim of this instant case.
Partnership firm is the petitioner.
Yes.
Yes, I am this writ petition emanates from a FIR. I am the complainant of that FIR. I am the victim who has been cheated 1.45 crores.
My grievance is simple, my lord.
They are
No. Why? Let me place my case first. Lordship, I am a Mumbai-based company. The issue started when on 26th of November 2025, I received a notice from my bank of Kotak Mahindra Bank that my current account has been freezed. Pursuant to a notice issued by the police officer from Siliguri police station, notice was dated 25th of November 2025. Thereafter, I inquired and I found, Lordship, that a case has been instituted. A case has been instituted against owner Munna Jewel. And Lordship, it's the complainant is Sajjan Agarwal. He is a Lesser Silver. Hunar Gold. Sajjan Kumar has. Lord, I have just missed the brief.
May I, my lord, beg what?
We appear for Sajjan Kumar. The first informant, de facto
It is, my lord, regarding freezing of the debit action of the petitioner's account, my lord, on the basis of a complaint made by another person. The thing is, my lord, as per the covering letter, it was scheduled to appear on the 30th of July before your lordship. We received it yesterday. Today, my lord, we have sent for the instructions.
You have not got instructions.
No, my lord.
Yes, Lordship,
you have given in the communication letter that this matter will appear on 30th.
Lordship, that is the fault on the part of the.
Then you have to suffer for that. The learned advocate appearing for the state.
My lord,
sub-
kindly
subject-
grant us the leave to appear and represent the first informant in this matter.
Whether that is required or not.
Yes, my lord. I am the victim, my lord. My money is
It is for you to take steps accordingly.
lordship.
The learned advocate appearing for the state submits that in the communication letter, it has been stated that this matter is due to appear on 30th. This matter on 30th.
Great. Mark it.
Light up. Yes, next. SIR disposed of. Next. 28. Why?
I have served the copy.
Day after tomorrow on the prayer of the learned advocate for the list this matter 30th. 30th. Yes, next.
Lord, I am appearing for the Kuchbiar Jilla Porishad.
29.
29.
29.
For 10 years, more than 10 years, 40 days in each year.
Regularization.
He is entitled to get them as a benefit of the finance notification and the Jilla.
Enhancement of the remuneration.
Yes, and my lord, the Jilla Porishad has several times sent the, my lord, proposal to the authority, my lord, to the secretary of Panchayat and Rural
Yes, ma'am.
Development Department.
Who is for the Secretary Panchayat and Rural Development? Yes, see, you are appearing.
Lordship,
Why
there
have
is
you
a
not
direction
taken
for
a
filing
decision?
report, Lordship. There is a direction for filing report, Lordship. We got.
Why?
Report, only report, not the affidavit, Lordship. Lordship, he has not submitted the prerequisite documents, Lordship.
Who has not submitted?
The petitioner, Lordship.
I cannot, my lord.
It's
yes,
the
yes,
Jilla
yes.
Porishad who is forwarding. Jilla Porishad is forwarding all the documents. The petitioner Jilla Porishad has referred to.
But they.
The last letter is page 36. By the Jilla Porishad to all documents.
The Jilla Porishad saying they have submitted everything. Jilla Porishad is before is on your left. They are saying they have forwarded all the documents. What documents you require? By the no, what documents you require? The certification. All right, do one thing. You communicate to the Jilla Porishad what are the documents that is needed. Immediately thereafter, the Jilla Porishad will comply with that. I fix the time limit to take a decision on that. So within 1 week, you send the requisition to the Jilla Porishad. Within a week thereafter, Jilla Porishad will comply with those and you take a decision after that.
This petition, my lord, the list of the cancellation is already worked more than 10 years, 40 days each year. Possibly, might make it serial number 8.
Yes.
Now you just try it out to 36. This has to be 36. Yes, additional officer has said.
Yes, page 34. Please see page 34 of the writ petition, not your report only. Please go through the report, writ petition.
And the last letter by the executive Jilla Porishad, that is also said by the additional executive officer, that is 36. Your lordship will get the first line. I am sending here with the documents in connection with the books of finance and benefit such and such lordship. For 8 years.
Oh, they have sent all the documents. You are sitting tight. Why they will again send? What is your reply? You have not said that there is any discrepancy. You have not said repeated letters were issued to you. Please take a decision.
One letter was there,
Where is that?
They are saying that I am ready and willing to give fund to give the benefits of that.
Where is that? Where is that?
It's 31.
Yes. Yes, district magistrate has sent the requirement for fund. Has sent. No, document, joint secretary asked the district magistrate to send the requirement. What has the district magistrate done? No, after that, why? Because please see the document at page 31. The joint secretary says Panchayat and Rural Development asked the district magistrate to give the, what is the fund, requirement, proposal for requirement of fund. Now, how can you take this plea? Additional executive officer has said they have been engaged, discharging their duties. That also they have forwarded on 15th of June. All right. The learned advocate, missing learned junior government advocate, prays for a day's accommodation to revert back with day after tomorrow. 30 তারিখে রাখুন to revert back with necessary instructions. আচ্ছা, এখানে একটা তার উপরে একটা লিখুন, the petitioner has sought for a direction upon the Secretary, Government of West Bengal, Panchayat and Rural Development Department to provide them the benefit in the light of the memorandum dated 16th of September 2011. First up, the learned advocate appearing for the petitioner submits that in spite of the fact that the Kuch Bihar Jila Parishad has forwarded necessary papers and documents to the concerned authority, no decision, the benefits in terms of the memo dated 16th of September 2011 has not been disbursed in favor of the petitioner till date. First up, the learned advocate appearing for the Jila Parishad draws the attention of the court to several annexures to the writ petition in support of his contention that the additional executive officer Kuch Bihar Jila Parishad has forwarded all necessary papers and documents Please give her a better copy. Has forwarded. Why have you given her a blank copy? Has forwarded all necessary papers and documents to the Secretary, Panchayat and Rural Development Department, Government of West Bengal. First up, he submits that all materials and papers are in the custody of the Secretary, Panchayat and Rural Development Department, and they are sitting tight over the matter. Full stop. Faced with such situation, Ms. Singh Lanet, Junior Government Advocate, prays for an accommodation to revert back with necessary instructions. On the prayer of Ms. Singh, list this matter on 30th under the same heading. Please provide, Ms. Singh, what illegible copies, please supply the page numbers. Other pages are legible. Yes. Call the next. Call the next matter. Yes. Yes. What is your instruction?
My lord, kindly take up the instruction filed by the state yesterday. Kindly take it. Can it be that a 2 big of land? My lord,
You
just,
have got yes or no?
my lord, this money was given on for the purpose of, there was just construction work on that account, not on the account of the land.
Have you stated that in the writ petition specifically which amount has been paid, which has not been paid?
My lord, in my writ petition, I am claiming only for the land, not for the construction work.
You have not specifically stated for that. Sir, you have not specifically stated for that. Please show me that. You have stated that you have got for the structure and not the land. Please show me that.
I'm claiming only for the land.
Not the structure. Please file a supplementary affidavit with regard to that.
Structure they have
Disclose.
already paid. Structure they have
Where
paid.
have you stated that structure they have paid?
Structure they have paid.
Where
So
have you
allow me to
stated?
file a supplementary affidavit, my lord, and also to challenge this circular also, this instruction also, my lord. Allow me. That's why, my lord, I'm saying that let them file this through affidavit. I will file my reply. There I will disclose everything, my lord. I will disclose everything. All the documents which are handed with me, I will place those. That their document shows that it was paid towards construction and not for land.
Where is that document? Show me.
But that is not handy right now. I want to place it through affidavit, my lord. Kindly allow me, my lord.
The learned advocate appearing for the petitioner submits that the petitioner has received compensation in respect of the structures which has been acquired, but the petitioner has not received any compensation in respect of acquisition of the land. First of all, a query of the court as to whether such fact has been specifically stated in the writ petition. The learned advocate appearing for the petitioner prays for liberty to file a supplementary affidavit. Full stop. On the prayer of the learned advocate for the petitioner, leave is granted to the petitioner to file a supplementary affidavit. Better would be, I'm asking you, if you want to withdraw to file afresh. Choice is yours.
We'll file the supplement.
All right. One option I have given to you, you have not accepted. Now you know the
But I
consequences.
was suggesting let them file affidavit in opposition.
They will not file affidavit in opposition
Because
fast.
the calculation
Please do
sheet,
disclose
my lord,
content.
the calculation sheet is also required.
Please make up your case fast.
My lord,
Then
I will.
think whether they will be directed to file affidavit or not.
My lord.
Supplementary affidavit disclosing all material facts relating to acquisition of the land in question. First up, on the prayer of the learned advocate for the petitioner, leave is granted to the petitioner to file a supplementary affidavit. Let's a supplementary affidavit be filed within
2 weeks, my lord.
Within 2 weeks from date. First up, supplementary affidavit shall be served upon the learned advocate for the respondents. First up, petitioner will be at liberty to mention this matter for inclusion after the supplementary affidavit is filed and served upon the respondents.
The affidavit of service.
Affidavit of service taken on record. Yes, next.
Type for the private respondents.
Private respondent.
For the respondent
Before that
number.
one, I just.
Siliguri
I am for the
respondent number
Before that, I raised a preliminary objection, consider prayer of the writ petition.
Kindly seize the last order.
No, but before that, can you see my preliminary objection in prayer at page 14?
Page 14.
Yes. Can you see what is the prayer? Is there any mandamus? Nothing. What is going on? We are liberal, but there's that type of liberal, can you see? No read of mandamus, session.
After demolition order passed.
This
my
one,
lord,
no.
This should not.
This is one of, this is one of,
This
what is this?
not be the way where you are filing a writ petition, Mr. Ghosh, and you are moving the writ petition. This is not a writ petition.
Yes, this is my.
Is it a writ petition?
No mandamus, no session, nothing.
Is it a writ petition, Mr. Ghosh?
Going by the form, my lord, no.
Nothing, not form, substance, nothing.
What is the grounds,
Not-
and the
may
grounds?
may not be by
But
substance.
this is
my lord.
appellate side rules is absolutely correct.
Now, Mr. Rai, if I have to go by the appellate side rules, those procedures, none of the, not none, majority of the matters cannot be taken.
Because she knows that I am on that
No, my lord,
very
after
strict,
a-
because she knows it, because
What will
that
be
should
done?
be.
Nowadays,
This is ground, G1, can you see ground is 12?
if I look into those.
Yes, I know it,
cannot-
my lord. This is why I was trying to give my junior the knowledge part, this part, these are very particular, but here can you see page 12 grounds? This is
But you
this.
have not said any strong words to Mr. Ghosh, that is why he's.
But can you see that experience? I have been called, why I have given this knowledge in the Jyoti versus matter. Then Subhanahu has advised me, it's a mediate knowledge. I brought the logic books. Then I argued. This is what really, can you see ground? What is this? 12.
Look,
But you're not, I'm not,
This
I'm very liberal,
objection,
but
my
this
lord,
is.
this objection, my lord, is coming today. I bowed down. My lord, this is absolutely going by the form, my lord, is correct. But my lord also sees the last order. When this
That-
ground is
that
being
is-
taken.
Last order, Mr. Ghosh is.
We are confronted with an
Because I have
order of.
not Seen that, I've only gone through that.
But we'll-
Now, Mr. Rai is raising this objection, he's ready a valid objection.
My lord, allow me to come with an appropriate application. My lord, with supplementary affidavit, my lord.
No, not supplementary, how is this?
Millard,
We can't amend it.
my lord,
You
with
can't
that,
amend it.
with that liberty, my lord, kindly deals with the substance also.
No, if I don't do.
What is his
Why did you give it?
response to the
Now, what is the main
Entire thing
matter?
is not in
The
form.
main
What is the
matter is,
main
Millard, an order of demolition is staring at his face.
My
lord,
On the last occasion, your lordship had recorded that the Siliguri Mahakuma Parishad would come up with appropriate instructions. If that doesn't come up, Millard, it will be hard ex parte. SJDA was directed to come up with instructions that despite an order being passed by the executive officer of the Mahakuma Parishad, why they have not yet demolished.
My lord, I am for the respondent number 3, that's Siliguri Mahakuma Parishad.
Mr. Rai, you are for the,
Private respondent, I submit it, my lord. He has not.
and,
I am for the Siliguri Mahakuma Parishad.
Mahakuma Parishad. Yes.
My lord, you can, he argued that I said that everything is regularized. I'll show you.
Everything is regularized.
Yes, yes. I'll show you. But it's a litigation, but now the civil court, they got the order. In the second appeal, my construction is stopped. This is their motto. That is stop.
Second appeal.
Yes. This is like a joint some land dispute. This is a civil matter is there, this is defined, my lord. And the matter, they got the in second appeal, they got the injunction, my lord. The order was annexed here at page 19, my lord.
How is that relevant
No,
here?
no, I'm not saying this. I know you are already covered.
No, this is, Panchayat Samiti Siliguri. Yes, but.
My lord, all the directions have been complied with.
Directed the SJDA to come up with the report. What's
But I have taken instruction, my lord.
These are instructions.
Yes, in spite of when there was a specific direction, how could you say that, no, I cannot do anything? That was the query. What is your reply to that?
My lord.
Now it is over, my lord.
Petition, my lord, the petitioner has alleged that the private respondent has set up some unauthorized construction in violation of the sanctioned building plan.
Now, initially, my lord,
Yes.
one resolution was filed, and my lord, the private respondent, my lord, submitted a modified building plan, which was ultimately sanctioned by the appropriate authority. Now, my lord, I will request Mr. Devorshi Dhar, my lord, to hand over your lordship a report dated 25th April 2026.
Yes.
My lord, this report was prepared and submitted before this honorable court in the earlier round of litigation. This was dated 25th April 2026. The officer, Matigada Panchayat Committee. My lord, kindly consider, my lord, the second paragraph of this report, 25th April 2026, second paragraph. As per the
Yes.
inspection and measurement conducted by JE, junior engineer of this office, it is found that the construction has been carried out in accordance with the modified sanction plan passed by this office on 23rd of September 2025, except some minor deviation. It may kindly be noted that dismantling of the part of the building was carried out for the portion which was not in accordance with modified sanction plan. The photographs of the dismantling work are attached with this report. Now, my lord, kindly turn over and consider the observation part, the second page of the report. As per modified sanction plan, the allowed open space for the right side of the building should be 1.29 meter, and for the left side should be 1.20 meter. But as per the site inspection, it is found that the right open space as 1.26 meter and left open space is 1.15 meter. There is RCC column above the roof of third floor all around, which needs to be dismantled as per modified sanction plan. And the third deviation was the ground floor area as on site is 254.496 square meter, but as per modified sanction plan, it is 1.793 square meter. Malan, this report was placed before this honorable court in the earlier round of litigation, and the court, this honorable court directed the authority to take steps in accordance with law. Now, my lord, your lordship, kindly consider page 77 of the writ petition. This is a notice, my lord.
Yes.
Malad, this is a notice dated 1st June 2026, issued by the Executive Officer, Jalpaiguri Mahakuma Porishad, directing the petitioner, kindly consider, addressed to Pradeep Kumar Saha, petitioner. My lord, at the end of the page, copy 2, serial number 7, Messrs. SUV Construction, the private respondent. Now, relevant is, my lord, the second paragraph, my lord, accordingly. Accordingly, a date of joint inspection has been scheduled on 4th June 2026 at 12 noon at the site of the SUV construction, that is a private respondent, in connection with the matter stated above. The technical officers of the block development officer come executive officer, Matigada Development Block and Panchayat Committee will remain present at the site and shall assist in the aforesaid joint inspection. You are requested to kindly remain present during the aforesaid joint inspection. Now, they were present, Malad, at the time of joint inspection, and Malad, I will request once again Mr. Dhar, Malad, to hand over a report 9 June 2026.
Yes,
my lord.
Yes.
Now, my lord,
My lord,
this is-
here is the report.
This was prepared, my lord, pursuant to the joint inspection held on 4th June 2026. Now, kindly consider this report, my lord. In reference to the above, a joint inspection was conducted by the undersigned officials on 4th June 2026 in presence of Mr. Bhaskar Singh Kami, proprietor of SUV Construction, and Mr. Priyanko Saha, son of Mr. Pradeep Kumar Saha, who is the writ petitioner. In respect of correction or rectification done by SUV Construction, as pointed out, the Executive Officer Matigada Panchayat Committee report VD memo number Satansa dated 25th April 2026. Details of the inspection report is as follows. Now, my lord, I placed this report, my lord, just now. Then, my lord, kindly skip over the first four lines. Then, as found in the field, my lord, as your lordship got it, my lord?
Yes. Yes,
As
yes.
found in the field, after necessary rectification during the joint inspection conducted on 4th June 2026. Now, these are the, my lord, rectification which has been recorded. Open space 1.40 meter, left open space 1.22 meter. Then RCC column, as per modified sanction plan, right open space should be 1.29 meter, Now it is more than 1.29 meter. And left open space is required to be kept as 1.20 meter. Now the left open space is 1.22 meter. Therefore, more than that. Then RCP column has been demolished as per modified sanction plan. No column should be present. And ground floor area is now 251.793 square meter. As per modified sanction plan, ground floor area is 251.793. Therefore, my lord, this was also has been done. Then correction or modification done by SUV construction is in compliance with the modified sanction plan and conforms to the SJDA building plan. Now, my lord, kindly, my lord, turn to the next page. This is the letter, my lord, issued by the Chief Executive Officer, Siliguri Jalpaiguri Development Authority. My lord, this is dated 16 June 2026. And my lord, it was informed to the Executive Officer that the discrepancy was pointed out initially. My lord, the next page your lordship will find the last line that the correction or modification done by SUV construction is in compliance with the modification plan and conforms to the SJDA building rule. Now, my lord, this is the present situation. Now, my lord, your lordship will find that the writ petitioner at page 19 of the writ petition, my lord, there, my lord, filed a second appeal, which was taken up for consideration, my lord, on 17 June 2026, subsequent to this inspection. And my lord, this honorable court, my lord, kindly consider the order at page 19. Well, at page 19, your lordship will find that writ petitioner, the present writ petitioner, filed this writ petition against the private respondent. Now, relevant is, my lord, page 3 of this order, paragraph 4.
15.
My lord,
Yes, yes.
My lord, paragraph 4, my lord, at page 21. The parties shall maintain status quo with regard to their character as well as possession in respect of the suit property, as well as shall remain restrained from making any construction and or further construction on the suit property and or selling, transferring, encumbering and alienating the same in favor of third parties till disposal of Can 1 of 2026. Prior to this, my lord, we have, my lord, complied with the order, and my lord, as your lordship will find that 4th June 2026, my lord, inspection was held and thereafter report was filed. However, my lord, I found that these reports were not
No, these are
forwarded to
subjects, the suit property or this the property which was the subject matter of the second appeal, and this writ petition is the same.
No,
My
we
lord,
have purchased the land with a compromise degree.
No, this property is the same.
No,
This
these are-
construction
They
is the
said this is schedule was there too. We have purchased a property, there is a compromise degree, then they file a suit, the suit was dismissed, then second appeal, first appeal.
No, Mr. Rai, what I am saying is the
Schedule of the
property.
property, schedule property is from the same. But they have given two.
All right. So,
But that I cannot go there, but this is division bench judgment, second appeal at that time.
Mr.
Here, my
Ghosh, now the
Give me
inspection.
just 2 to 3 minutes. Will you kindly take page 27 once? The first inquiry report.
No, now, Mr. Ghosh, this is being filed today. If you want to challenge, you have to deal with this because now it says.
Let us come back with
Because
an
now it
exception.
says, Mr. Ghosh,
You just submitted.
after the inspection,
Yes.
you are also present at the time of
Yes,
inspection.
but why I say that the report and the observation that now the present site is in accordance with the rules, Millard is completely Millard deholds the records and
Then
the
you have to
earlier
challenge
inquiry.
this report.
That's what Millard has
Here is
said.
the report, my lord.
But this is a basic report, this is a.
Here is the report, my lord. Sir, sir.
But only one thing, at the time of inspection, it was in your presence. Did
But
you,
we-
did you raise any objection?
Yes,
at
there
that
is
point?
the objection.
Where is that?
Millard,
It is not recorded, Mr. Ghosh, anywhere.
Millard, if they don't endorse that in the report, Millard, we are helpless.
So have you said that in the inspection you have raised, have you pleaded that?
No,
Nothing has been attributed.
Then
Kindly,
it's merely a statement from the bar, Mr. Ghosh.
kindly take page 27 once, the earlier inquiry report.
This is, they have said this is their report, they have said,
No, not
regularizing.
our report. This is
No,
Mahakama
they
Parishad's report.
they have regularized. Who are you to say?
This is 26/12/2024.
Correct. Now Millet sees the open space, the last column 4, 5, 6, 7.
That
As per site,
Now it has been modified. They
Millet,
have,
it cannot be. It cannot be modified. Why I say this, Millet kindly marks the as per site 2.54 meter, 2.30, 1.40, 1.50. Now Millet sees the report which has been placed today before your lordship.
So they said not-
RCC columns in the third floor has been demolished.
Mr. Ghosh
Without demolishing the RCC columns from the ground level,
No, the
can the
RCC
open
column,
space
it's a cantilever.
can the open
It's not
space
like
be
this thing.
changed?
that is one part. Second part, Mr. Ghosh, the problem is if the, now what is there, it's there. Whether it's in violation or not, that's one thing. Now the second appeal, the division bench has said it's a status quo.
Status quo.
Then,
But
how
whatever
can
is
this-
there, even that is not in compliance with the rules.
but that cannot be touched now. The second appeal status quo order is there.
No, let us deal with the report. We will point out what are the discrepancies in the report.
That you can do, but with this order of status quo, what can be done unless that is modified?
Millet, that is a different thing. Millet, but we have to point out the discrepancies. At least, Millet, we have the right to take out an exception to say that what you have stated in your
My lord,
report.
then there
does
is no
not-
cause of action then. Something else, my lord. Can you see?
All right, do one thing.
Millet,
Look at the press petition.
My lord, in
Can you see? They say that there is no illegal construction. This is the main point. The Justice Kapur's order to
Mr.
rectify.
Rai, Mr. Rai, only one thing. Mr. Ghosh is right in saying, if the violation is with regard to the open spaces,
Yes.
without any demolition,
It's a by demolition. Can you see?
it
How
has
that
been demolished.
demolition?
It has been
RCC
demolished.
column has been
No,
removed.
That
this
is on the
this a
third
cantilever.
floor.
That is the
That is in the third floor.
I talked to my client, but this is not the beams. It's a cantilever. Mr. Ghosh, I is not the
It has been
engineer.
said RCC column is not there.
Third floor.
That's the report.
See beams, you see, this is a cantilever beams. So my lord, I can't say anything more. The report says this is their report. And what he will say. He has to make it.
Because,
So cause of
let him-
action goes, my
Let
lord.
him deal with this.
Yes,
Let
Millet.
him deal with this because there are two reports. One says right open space, left open space, changing without demolition, Mr. Rai.
And then
It's-
there's a
it's difficult.
demolition is there. Demolition is there.
Third floor এ demolition
No,
করেছে।
No, this is, no, he's not correct. But I
আরে
am
তোমার
taking
report, the report is saying
No, report, I am not, this is a report, I am not with the report. I am a, can you see? Third floor beams, we have removed. The open space, right open space, those are, my lord,
All right,
proper or
Mr.
not problem
Rai, I
resolved.
will be affected. Your construction according to you is in accordance. So let
But then,
me,
my lord, then they have to cost, impose the cost.
Why?
It is not properly formed. It is not been proper formed. Then impose the cost. Either they would do and, yes, my lord.
No, no,
But
let
that
us
should not be
come
allowed.
back
That should
with
not be
the
allowed.
supplementary
So-
affidavit, Millet. We'll
But
make.
how will be?
with supplementary
It
affidavit,
cannot
you
be.
cannot
Millet.
amend this.
I
So,
know,
my lord,
Millet, it cannot.
kindly,
It
this
cannot.
one of the petition or my lord, impose the cost. Your lordship, kindly say.
Again, another round, you will be filing, these things will be there.
Your lord. Mr. Ghosh, আমার খাবি চা করে।
Yes, Mr. Ghosh.
Millet, I,
Greet
coffee.
him.
Millet, coffee. Coffee আর snacks.
Yes, lord.
আসুন।
আমরা
Uh,
সবাই।
Mr. Rai Mukherjee, will you file a report annexing this?
Yes, my
I think it's, so do that by 3rd of August, you file a report, file a one-page affidavit or a report annexing this, give a copy, he will give it.
But the main part is that.
Both of them will file. The learned advocate for the SJDA authority and Shiliguri Mahakama Parishad files the inspection reports. First up, it has been stated in the said inspection reports that the construction is in accordance with the modified sanction plan. States that upon inspection it was found that the construction is in accordance with the modified sanction plan. Full stop. The respondent number 3 and 4 are directed to file their respective reports in the form of an affidavit annexing the inspection report and other documents. To stop, let such report be filed on or before August 4, 2026, upon serving an advance copy of the same to the learned advocate for the petitioner and the private respondent. First up, Mr. Rai Learned, senior advocate appearing for the private respondent, submits that there is no cause of action that there is no cause of action for filing the instant writ petition, as it is evident from the inspection report that the construction made by the private respondent is in accordance with the building accordance with the building rules. First up paragraph, petitioner will be at liberty to file exceptions to the report on or before 10th of August. List this matter before the next available circuit bench, subject to the convenience of the honorable bench. Yes.
Grateful, madam.
Yes. Banerjee, which item?
Item number 60, my lord, there was some urgency.
60.
60. My lords, perhaps have a division bench
That's
also.
difficult.
Would your lordship take it up at 4 o'clock? And in the event it is not reached, otherwise I will take my chance. The division bench outlasts 4 o'clock, it's my client's bad luck.
I can keep it tomorrow, because today it might be difficult.
Tomorrow, my lord, actually, I would ideally have gone back tonight.
You can join also virtually.
Virtually it becomes somewhat of an impediment.
The weather is fine now. You can stay back.
My lord,
Yes.
can it be around 4? If can I just
Today
come and
it
make
might be
it?
difficult because at
My lord, let
4
me
it
take
might-
my chance. In the event it is inconvenient for your lordship, I will not press. At 4 o'clock, my lord.
Yes.
Item number 60.
Yes. Not 4, then try at 3 if it is taken up.
3 o'clock.
After
At 3.
3 it might be difficult.
Fair. At 3 o'clock.
Yes. Subject to that division bench.
Subject to that division. I'm told it will not last long.
Yes, next.
Item number 61.
61. Yes. Yes, disposed of.
62.
Same.
271.
Disposed of.
Same, Lord.
Disposed of.
Same.
Disposed of. 5. Disposed of. 66. Disposed of. Disposed of. Disposed of.
69 Ambrosia.
Disposed of.
Anamika Pandey, Election Commission of India. ঠিক আছে? পান্ডে অনলাইনে আছে।
Offline donor.
সাবমিট হয়ে গেল? আচ্ছা, সাবমিট করে দিচ্ছি।
Principal bench is not functional today.
But I promised to come over here today.
You have promised, but I find several others. I do not know. One principal bench is functioning without all of you.
Now physical presence is not always required.
But even then you are here, all of you are here.
Yes. This is the magic that COVID has done for our profession. We are omnipresent now.
Yes.
I can see a omnipresence here, but your lordship cannot see.
Yes.
Division bench, item number 1. Well, item number 1, well, I am for the appeal and writ petition.
But I am for the respond number 5 college.
6 for the trust.
My lord.
But if your lordship recollects, my lord, on the last occasion, my learned friend has given up all other prayers of the writ petition except the first one, which in my very respectful submission, if your lordship may kindly have a look to the prayers in the writ petition.
Writ petition is in the supplementary affidavit.
No,
Yes, my lord.
Supplementary affidavit.
Prayer in the supplementary affidavit, page 55.
The writ petition has been annexed in the supplementary affidavit.
Supplementary affidavit, page 55.
এই আমাদের কিন্তু সার্ভিস করিসনি এনিওয়ে we have the writ petition, but I'll may place the prayers, my lord, from the writ petition. A direction by this honorable court to constitute a special investigation team comprising of high-ranking officials to investigate into the administration of the institute. The institute means, my lord, my college. Then, and other institutes under respondent number 4, around 600 institutes. Under the
number 4. Who is respondent number 4?
That is the university. Now it is named as Babasaheb Ambedkar University. But this was initially not that B.Ed University. Under the supervision of this court, honorable court, as it is evident from the facts and circumstances of the present writ petition that a considerable number of high-ranking state government officials or central government agency are involved in the misappropriation of funds using educational institutions as funds. Otherwise, it would be difficult to have a fair and independent probe. First is, my lord, this is, my lord, in the nature of prayer, in the nature of a public interest litigation. This cannot be, my lord, before by way of a adversarial writ petition. Number two is that the other 600 institutions are not before the court.
Already.
Where the learned single judge, my lord, has dismissed the writ petition on the ground that the writ court has no jurisdiction to go into the matter. But if my lords may kindly, my lord, have a look to, my lord, the order under appeal.
But only one thing, Mr. Dotto, is there is an interim order against which SLP has been.
Right.
Now, that relates to, I think, some police complaint. Where is that?
Yes, but that complaint, my lord, your lordship should find, my lord, at page
54 of the can 1.
Yes, but I have it, my lord, at page 196. Be that as it may, your lordship may kindly, my lord, have a look to, my lord.
54 of can 1.
Yes. My lord, the coordinate bench, my lord, hearing this matter, my lord, on 2nd of July 2026, if my lords may kindly have a look to that.
Maintainability point, my lord. My senior pen argued regarding maintainability point.
দর্শক একটা প্রশ্ন করেছেন উত্তর দিই 2nd of July 2026
What is the page?
Yeah,
Can one,
yes.
page,
196. In Can 1, it's page 196.
yes, so this is a complaint made before the
SP,
SP.
right.
So, on this, what order was passed?
So 2nd of July, my lord, the coordinate bench in this appeal had passed an order. If your lordship may, lordships may kindly have a look to that. Paragraph
of
number
July.
6 first. Second page, para 6. A complaint was lodged before the SP on so and so. Allegation is that no steps have been taken in response. Learned Triple AG is directed to obtain a report from the SP in response to pages 196, 197 and 198. Now what the police does is,
This order was passed on the stay application.
yes, which is pending consideration before my lord. Now,
Technically speaking, Mr. Dotto, when the writ petition is dismissed, nothing remains to be decided in the stay
Right.
application. But now, the only difficulty is that an interim order in the stay application has been passed, carried before the Honorable Supreme Court, and there an interim order has been passed.
right,
So now,
yes, my lord.
the sum and substance of that is inaction of the police with regard to a police complaint. Complaint,
Subject matter of the
Read petition is something else.
Mr. Chatterjee, Mr. Dotto, how can we now say it's not the subject matter of writ petition arising out of an appeal? Arising out of an appeal, an order has been passed.
Right.
From there, it has been carried before the Honorable Supreme Court. It's not that merely by going through that beyond the scope, it has been set aside on that. Entertain, passed an order of stay of operation, and other things are there. So now what would be the
Milord, if I've been able to, Milord, read the mind of the court, Milord, I don't think, Milord, that there is any bar in proceeding with it.
you are technically correct that there is no barring, there is no stay of
Right, of the proceedings.
proceedings of the appeal.
Yes, yes.
There is no dispute with regard to that. Now, but the appeal is disposed of. What remains with the interim order?
It becomes infraction.
Now, but the question is, the matter is pending before the Honorable Supreme Court arising out of that. Does it not entertaining this? Does it not amount to overreaching the order of the Honorable Supreme Court?
Milord, may I say
When
this,
the
Milord?
matter is pending.
Yes.
And the Honorable Supreme Court has directed issuance of a notice. That's the only thing. It's not that Honorable Supreme Court has stayed all part of the proceedings.
Yes, Milord.
But the effect, if it is disposed of, what could be the effect?
Milord, please have a look to Milord, the other prayers in the writ petition. Those have gone. Therefore, Milord, on the day, Milord, the coordinate bench, that is on 2nd of July, had passed an order, which is now before the Supreme Court. Milord, it was in connection with the other prayers, which is today given up.
So it's anyways infraction.
So, insofar as this 2nd July order is concerned, and Milord, subsequently, whatever is pending before the Supreme Court.
So, we appreciate that, but can we say from here that it has become infractuous?
No,
That's the only.
but we will
difficulty
not
now.
invite this division bench to make any comment, Milord, in regard to the proceeding before the Supreme Court and the width of the proceeding before the Supreme Court. What we are respectfully submitting is the prayer that is surviving today is not before the Supreme Court.
No, we appreciate that. But the effect of what happened?
Bullet.
The submission which you are making. So the submission which you are making that prompted this.
Triggers this.
So wrong. May I say this, Lord? My personal opinion is, subject to your lordship's consideration, is possibly, Lord, there is no difficulty in hearing this matter, because otherwise
When the matter is fixed before the Honorable
Lord, the Supreme Court has not fixed any date.
4th August.
4th of August.
Issue notice returnable 4 weeks, yes.
4th of August, Mr. Doxy, that is, you can get it clarified from there. And you can, because in view of this, because according a litigant, they may give up their prayer at any point of time. So now they are giving up that prayer. What will be the effect? You can make that submission and get it clarified, because what is troubling is that nothing would survive if the main proceedings is disposed of either way. Either way. So rendering a proceeding before the Honorable Supreme Court
in a civil litigation, if an interim order or revision is pending against an interim order, if the main suit is disposed of, the revision application gets in front. It doesn't mean that because the revision application is
Mr. Chatterjee, I'm not
we have
disputing.
another very important point. It's a point with respect to the petitioner's local standard. To maintain this before your lordship. That goes to the root. Lord, today.
That's the issue in the appeal.
Absolutely.
That's the issue in the writ petition also. Whether he could have maintained the writ petition as well as this appeal. That's so.
There is no quarrel on that. Today, if your lordship decides that he has got no local standard, everything before the Supreme Court also gets disposed of. And they have to challenge
So
this
the
order.
example,
this way or
Mr.
that.
Chatterjee, what you have said with regard to an interlocutory order challenging civil division,
Well,
is well and good, but
stay of the further proceedings
the
as
question
well.
is, near pendency is one thing.
Yes.
If the civil division is entertained, some interim order is passed, the
Some
whether
interim order
at
is
that
not
point.
staying. There may be a stay of operation of the order. But
Yes,
if the
staying,
further proceedings are not staying.
Mr. Chatterjee staying, at times, some submissions are made. You will object to that. You will be saying that I will not make the prayer. Let us take, for example, I'm giving you an example. An application for amendment of plaint or written statement is rejected either way, and a party comes to the court. And a prayer is made by the petitioner, kindly stay the operation of the impugned order. You are accustomed to that.
Yes, yes.
Sometimes it
Yes,
happens. You cannot deny that, and that order is passed.
It is passed.
That order is passed, but there is no stay of the proceedings.
So proceed.
Yes.
Yes. The suit
But
proceeding, then
but the-
105 comes into play.
Yes.
That
105
lawyer who's done some work, he will say that I will challenge that order on 105.
105 is
That
there.
doesn't mean that the suit doesn't proceed.
Milord, sitting in appeal court, Milord, while hearing interim orders, Milord, your lordships may stay the interim order, modify the interim order, pass further interim orders, as also stay of all further proceedings before the court, Milord.
Please take us to that complaint once, because
But that is page 196 once more.
Still arguing on the point of maintainability, or I get.
all right, Mr. Dottu, you take it. Yes. Yes.
My lord, lordship, you kindly have a look into, so already my learned senior pen, my lord pointed out regarding the prayer A. Prayer A, my lord, for my satisfaction, that is supplementary affidavit, page 55, direction by this honorable court to constitute a SIT. My lord, regarding the corruption, then kindly come to, my lord, 2nd July 2026 order passed by the coordinate bench. My lord, that order not, my lord, read, my lord, minutely from paragraph 1. Mr. Joydeep Choudhury. Mr. Joydeep Choudhury is the, my lord.
Yes.
Yes. He is the one of the, my lord, member of the trust respondent number 6.
File secondary order sheet नहीं file दे.
Trusted member बोले.
Managing trustee.
Yeah.
Managing trustee.
Managing trustee of
Yes.
My lord, with due respect, I'm submitting, if your lordship kindly read petition cost title, respondent number 6, Osini Chaudhary Educational Trust. That trust, one of the managing member, that is the Joydeep Chaudhary. That Joydeep Chaudhary who appeared before this honorable court. And he was the additional, my lord, advocate general of this court. My lord, what has happened? Mr. Joydeep Chaudhary, learned advocate, appeared for the respondent number 5. Respondent number 5 means Alipur B.Ed Training College on the capacity of an advocate, not personal. Thereafter, Mr. Bikramjit Ghosh, learned advocate, represent the respondent number 6. On perusal of the document annexed to the application for stay, it appears that both the learned advocates represented other parties in the previous proceedings relating to the present list. Appeared on behalf of the other party, such as NCT, and appear on behalf of personal capacity, appear on behalf of, my lord, additional advocate general. Everything has happened in this court. And thereafter, this order with, I am sorry.
They retired from that matter.
Thereafter retired.
Yes.
And thereafter, what has happened? My lord,
It happens at times, busy advocates
personal capacity,
they,
respondent number
at
6,
times
with due respect,
do not find time to see for whom they are
my
appearing.
personal capacity, he is the member of the trust. He is the member of the trust.
Very interesting.
Thereafter, what has happened? Learned honorable division bench only, my lord, obtain a report regarding page 196, 197, 198 of the stay petition. These three complaints not only annexed in the stay petition, if stay petition goes, that 3 complaints annexed in the writ petition, that writ petition we have filed, my lord, supplementary evidence. So 3 complaints only call for a report. After the order of this court, the superintendent of police, my lord, made a notice to my client, appellant. And thereafter, he requested me that the original complaint, the FIR is the backbone of the criminal proceeding. Original complaint is missing. So he requested me to file another complaint that was written in the year 2022. I lost the complaint. Ditto. Thereafter, what has happened? Thereafter, an inquiry, if your lordship kindly have a look into the criminal proceeding, the notice, everything, notice under section, notice under section 94 of the PNSS. Bharatiya, my lord, if your lordship
give them copies.
my lord,
Yes.
একটা কপি দিয়ে দাও, অনলাইনে পাঠিয়ে দিলে হয়ে যাবে। ওই কোনটা বলুন তো? ওইটা চলে গেছে, পরে ওটা পরে দিচ্ছি। My lord, section 94 of the PNSS.
Have you given copies to them?
My lord, they দিয়ে দেন? They have annexed in the special leave petition, my lord. They have annexed.
Here, special leave petition defined counsel is appearing. Please give them
আমাদেরগুলি
copies.
দিয়ে দাও না, আমাদেরগুলি দিয়ে দাও। সিজার লিস্ট।
This is most unfortunate.
নোটিস। ঠিক আছে, আনফরচুনেট, my lord, thereafter what?
I don't know why my language is subject of why these submissions are made.
Thereafter, thereafter,
Initial registration of the court is that whether at all here this matter not Supreme Court.
well, only
Yes, then the submission should be made in connection with the surviving claim.
But the only thing is that whether this should be taken up now or it should not be taken up
my
now.
lord, not the one thing, my lord.
So if you enter into the merits,
No,
then
not only the not, my lord, thereafter what has happened?
if you enter it, with regard to this, an SLP is pending because pursuant to an direction,
yes, carefully,
something
your lord.
was done. They have challenged that. It has been stayed, and with regard to subsequent steps, they will be at
My lord-
liberty to take steps. So that's a different chapter altogether. Now the question is, in view of that pendency of the special leave petition, shall we take up the hearing of the appeal? Yes or no? Please submit on that.
But what has happened thereafter, my lord? Thereafter, independently, after inquiry, pursuant to the order of judgment and order of Lolita Kumari, my lord, inquiry was conducted. Under
We are
section
not
173.
going into the merits of the
My
matter.
lord, no. My lord, what has happened?
26 years now.
My lord, what has happened? My lord, already criminal investigation is going on. Criminal investigation is going on. So, my first prayer that SIT form such and such is gone already, my lord. My lord, in fact, my appeal. Yes, my appeal is in fact, criminal proceeding is going on. And
So
my
do you
lord.
want me to want us to record that?
Yes, my lord. Yes.
Then the second July
160
order should also go.
183 years, man.
Yes, that go.
183, my lord.
Mr. Dotto, if the appeal becomes infructuous, is there any necessity to record the interrogatory orders also go?
Already infructuous, my lord. With due respect, I'm submitting before your lordship. Other prayer already gone. Give up. First prayer SIT. That already case started. My statement before magistrate already recorded. Everything has gone, my lord.
ঠিক আছে
If you want that, we can
Not I am
record that.
not
withdraw
withdrawing. In view of infructuous, in view of the
I
fact.
will record, we will record your submission
My
that in
lord.
view of subsequent
My lord.
events that took place during the pendency of this appeal has become infructuous.
Another thing, my lord. That on second point, my lord. And one thing, my lord. Second point, my lord. If your lordship kindly have a look into.
I shall be going to that. If
No,
you say,
one IA application, they filed before the Supreme Court for stay of the FIR. Kindly have a look into.
that's the Honorable Supreme Court has
No,
passed an
they are
order.
not granted.
No, that, what the Honorable Supreme Court has passed, not granted, it's there. We will not go into
Already-
that. We will record your
This is
submission
their
that
knowledge.
is.
They want, this is their knowledge.
It is
That
pending there.
one criminal proceeding is pending against them.
What is your submission on this appeal?
Well,
If you say that it has become infructuous,
Infructuous, my
so we are recording that.
Yes, ma'am.
That's the end of the matter. Yes,
Yes,
Mr.
ma'am.
Dotto, you cannot have any
No,
grievance on
I
that.
cannot stand in the way. Stand in the only thing is, Milord, what has happened in between will go on prejudicing.
That is one
Yeah.
aspect, your lordship.
Yes,
Because
yes.
after taking advantage in the appeal,
Whether you will allow them to withdraw.
then to withdraw.
No, I am
and
not
then say
withdrawing.
that whatever has
Infructuous
happened
in
in
view of the
the
fact, FIR
that will go
started.
on. That can't happen.
And independently FIR started, not on the basis of the order of the High Court.
You can't do that.
Independently.
Milord, there
after
are
inquiry,
orders where
my lord,
your
FIR
lordships,
started.
there are orders where your lordships have not allowed, Milord, a litigant or the petitioner
Yes,
to
yes, yes.
withdraw because.
Once he has taken advantage of some orders, thereafter he cannot withdraw
Yes,
that.
yes,
proceeding.
yes.
Cannot. Today.
I am
Then
not
what we are
on the
doing, we are keeping
You are
it
not withdrawing.
after the, make that.
I am not withdrawing, my lord. In view of the FIR was started, matter is infructuous.
This is also.
No, 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 But how can this be? First he gives up the other phrase in the writ petition.
No, other already.
He gets interim orders and
Then gets an interim order.
Not-
First
not-
interim order gives a phrase and
Not-
today says that the surviving
Not on the
phrase
basis-
is becoming
Other with
fructuous.
due respect, I'm submitting not on the basis of the interim order.
No,
Case
তাহলে
was
pending.
started, case was started independently,
Pending.
issued independently.
after inquiry.
On the basis of the order.
Not on the basis of the order, nowhere it is stated in the FIR.
On the basis of the. That is why you signed in the document.
এই একটা
Kind-
there was a report call for from the state. সেটা কোথায়?
Steve has not submitted.
Kind of a look into,
Mr. Chatterjee is trying to bowl a googly. Told Badmaishi বুঝতে পেরেছে।
kind of a look into the first page of FIR. Nowhere stated pursuant to the order of the Honorable High Court.
You appear before the
FIR was
Honorable Supreme
started.
Court.
High Court is not a 156 court.
No, but
Take all
nothing.
points there, get it clarified. Challenging and order dated Second July 2026, passed by coordinate bench
First time.
in MET in this instant appeal. The SLP by you,
Yes, no.
by
I would not get.
which respondent?
Mr.
Mr. Dotto, please tell me, please tell us which respondent.
This is the copy of the essay.
Please tell us which respondent. Respondent number 5. 5. The respondent number 5 preferred a special leave petition being being special leave to appeal within bracket C numbers 23810-23811/2026. Full stop. By an order dated 20th of July, by an order dated 20th of July 2026, the Honorable Supreme Court passed an order of stay of operation of the impugned order until further orders. Full stop. The Honorable Supreme Court further directed that there shall be no coercive steps to be taken against the petitioner till the next date of hearing. Petitioner therein, that is the 5th respondent hearing till the next date of hearing. To stop, it has been submitted that the aforesaid matter is expected to appear before the Honorable Supreme Court on 4th of August,
2nd July.
2026. Full stop. Since an interim order has been passed by the Honorable Supreme Court staying the operation of an order passed in the appeal, this court is inclined to adjourn the hearing of the instant appeal. Full stop. List this matter, or we can give you liberty to mention after that matter is disposed of. Right? You will not be affected because you are protected by that interim order, and they
No,
also do not want.
but the investigation will go on.
Investigation is on and the police is calling us for.
Investigation, that's a separate chapter you have to challenge. That's neither here nor there. If you are agreed with those investigations, you are at liberty to take steps there.
But then the state had to file a report before your lordship.
2nd July order last time, my lord, when this matter was taken up.
You have the
My
report
lord.
with you.
The state is the most neglected getting it.
Now, Mr. Doctor, there will be, Mr. Doctor, there will be again one difficulty.
Most
Because that, yes, that interim order has been stayed, meaning thereby filing of the report also has.
Right.
Liberty to mention, I think that's better because in case otherwise.
SLP is over.
Parties will be at liberty to mention this matter for inclusion after the special leave petition is disposed of.
Or in case of other exigencies. Or in case of.
In case of other exigencies, strictly upon notice to each other.
Report dated 18th of July is with me. That will be.
Deeply obliged.
That's been stayed, Mr. Misro. 18th of July is, no, that's before the August Supreme Court's order, but technically, keep it with you.
The order in the SLP of 20th. Before the Supreme Court.
But
Not
will be
granted.
filing
Not
may be
granted.
a problem now, because the entire thing is stayed.
Grateful, your lordship.
নাম দিয়েছে দিদি
দিয়েছে
দিয়েছি আমরা।
এই সব ঢোকা আমার চারটে সেটি হল চারটে
হ্যাঁ
Responded 500.
হ্যাঁ সিঙ্গেল
State আর হচ্ছে গ্রাম। Item number 32.
My lord, I'm for the petition, my lord.
I'm for the petitioner, my lord, but senior
Virtually
will
by
lead
my
in this
two
case.
juniors,
Yes.
my lord, and
May it please me,
today respondents have make their submissions.
Yes, yes.
First off, my lords, to begin with, if I can have my lords for a moment on couple of paragraphs of the writ petition. Now, we can choose any number between 1 and 10 on a random basis. For example, if we take paragraph number 10, 20, and 30, because both of them are multiples of 10. Let's have a look at paragraph number 10. We can take 9, 18, and 27 also. Paragraph number 10.
Yes.
Your petitioner states that on 29 January 2021, the petitioner was issued a notice for production of documents for the period 1920, but the petitioner missed the said notice as it was not brought to the notice of the petitioner by the petitioner's accountant. Now, this accountant story, Milords, is coming from paragraph 7, 8, 9, 10. Then, Milords, paragraph 11. The so-called notice, the reminder was such and such when the petitioner accountant didn't brought it to his knowledge. Paragraph 12. As the said notice in DRC 01 was not brought to the notice of the petitioner by whom? By the petitioner's accountant. Then, Milords, paragraph number 17. The user ID and the email accountant who did not inform the petitioner despite having received the intimation in his email. Then, my lords, paragraph number 20. The petitioner was totally dependent on his accountant for taxing matters. The said accountant, on through searching the GST portal, found thereafter he participated once also. Thereafter, my lords, again the petitioner role is there. That, my lords, will find is in 10, 20, then 30, or in 29. Your petitioner state that the order has been passed in such and such. Acha, the petitioner accountant who handle all tax matters did not inform the petitioner about the adjudication order. Then paragraph number 30, your petitioner states that on or about February 2025, the state accountant, erstwhile accountant, Mr. Utsav Chakravarti with name, names have been taken before also, left the office of the without any prior notice. As a result, the petitioner started searching for a new accountant. My contention, then paragraph 34, the email ID and password is maintained by the accountant who did not inform. Paragraph number 35, the erstwhile accountant did not inform and did not perform his duties. My contention today is that out of total 50 some paragraph in the writ petition, 17 of them are dedicated to the accountant. That accountant, fortunately or unfortunately, is not here before my lordship. Now today, either way it is decided. It may be decided in favor of the writ petition, it may be decided in favor of the revenue. What the stand of the accountant, my lord, says will never be looked into. Whatever the writ petitioner says, that will be taken as the stand. That, my lord, is my first little bit of objection that is there. Now, there are 2 or 3 very, very important and vital things that has been taken by the writ petitioner. If I can have my lordship for a moment on paragraph number 27 of the writ petition, and then I will take my lordship to the annexures as well.
27.
27. They say that the learned West Bengal Taxation Tribunal, by a judgment and order dated 24th of August 2021. So the order was passed on 24th of August 2021.
Yes.
The GST itself came into implementation in June 2017. In RN 479 of 2017. So this particular list that they're referring to here in paragraph 27 was filed in 2017 before the GST regime was there. It was filed in the VAT regime because the GST obviously was not there. Therefore, the order has to pass in the VAT regime. In Balaji Hydrocarbons Limited versus STO Investigation Unit and 2 others and other applications declared that the Commissioner of Sales Tax. So herein we are not talking about the commercial taxes that is applicable under the GST. What is being referred to is that in the 2017 list, by way of a judgment of 2021, the Commissioner of Sales Tax has no jurisdiction to create the ITC investigation unit. So a particular authority who created a unit did not have that jurisdiction in view of a circular passed in 2014. Declared unit and declared that the trade circular of 2014 dated such and such is found to be without jurisdiction and invalid and illegal. This, my lords, happens to be the first point. They say that because this unit ipso facto was created and that was bad in law, therefore the subsequent transfer of the unit in 2017 after the VAT regime was over and the GST regime came up, that was also bad in law. But that circular of 2017 is not under challenge. Today, my lords, my submission is that anything and everything that happened under the VAT Act will remain under the VAT Act. Today, there is a new law that is there. If the previous officer who were not created in accordance with the VAT Act, any taxation process or adjudication process or appellate process that take under the VAT Act, that would be still looked into under the VAT Act. But that does not have any relevance today under the GST law, and I will explain why. Paragraph 28, your petitioner says that the ITC investigation unit has been declared illegal and respondent number 1 has no jurisdiction to conduct the adjudication proceeding. Now this, my lords, needs to be read with order at page 84. What the order was. Or maybe before that, if I can have my lordship for a moment on page 83 as well.
Page 83.
83, my lords. This, my lords, is a notification that they have relied upon. 2017. The governor is pleased hereby to declare that charges, circles, large taxpayers unit, information system division, data analysis wing, central audit unit, central registration unit, central refund unit, STDS cell, central section, tax recovery office, bureau of investigation ranges, ITC investigation unit, and other officers, including administrative officers of the Directorate of Commercial Taxes, West Bengal, existing under the West Bengal Value Added Tax Act 2003, and the rules framed thereunder shall be deemed to also have been set up under the West Bengal Goods and Services Tax Ordinance 2007. This particular circular, my lords, this circular happens to be dated 21st of June 2017. This is not under challenge. This has never been challenged before any law, any court of law. So it exists as it is. What has happened? One set of officers who were operational under a particular act have subsequently been subsumed. Why this has happened? My lords will recall that before the GST regime came into place, every indirect taxation under the central legislation or under the state legislation used to happen as per Article 246 of the Constitution of India. Now, Article 246 of the Constitution of India had some very watertight compartments that were built. There were 3 different schedules that were there. We used to call them list 1, list 2, and the concurrent list. Anything and everything that falls within the list 1 used to be the exclusive jurisdiction of the union government. And it was only the union government that has to frame law in regard thereto, including indirect taxation, that would fall under list 1. In respect of list 2, it was the state government that has the exclusive jurisdiction to frame any law, including indirect taxation, that used to fall under the second list. And then there was the third list, concurrent list. We all know what used to happen with them. There was the doctrine of apophyte. We are not bothered with it. Under the first list, there were 2 different entities that was there. One was entry 84, and then there was an entry 92C. As per entry 84 of the first list, there were certain acts that were framed by the union government. One of them, the most popular used to be the excise law. Then service tax was there. Then there were other taxes that were there. There were additional taxes upon customs that was there. There were certain cess and surcharges that were there. For example, the Swachh Bharat cess was there, and education cess was there. There were different cess. All of them found their foundation from 246 of the Constitution of India. Similarly, when the state was given the similar power, under the second list that was there in the 7th schedule, the state also came up with different laws. The most prominent among them was the VAT law. VAT was there. VAT sales tax was there. Then thereafter, entertainment tax was there, lottery tax was there, entry tax was there. All this used to fall within the state list, and the state, by the way of their own legislation, has taken into account, and used to surcharge the indirect taxes were there. I mean, what we all know is that every taxing statute is an enabling statute. There has to be an enablement that has to be there, and the foundation thereof comes from the Constitution itself. What happened, was that the 101st Constitutional Amendment was passed. When the 101st Constitutional Amendment was passed, the union has to sacrifice a lot of things. They sacrificed, the excise duty, except for liquor and tobacco. They sacrificed the sales tax. They sacrificed the additional component that was there on the customs. They sacrificed some of the cess and surcharges that were there. The state also sacrificed. The state sacrificed the VAT Act. The state sacrificed the central sales tax that was there, but we used to collect it and we used to pay it to them. We sacrificed that. We sacrificed the entertainment tax. We sacrificed the entry tax. We sacrificed the cess and surcharges and everything. Why did we do that? Why did the center and the state came on the same page? Because we wanted to create an integrated tax system wherein the power would be simultaneous as well as concurrent. Now, this has a very deeper meaning, and I will explain just what happened. So the idea was that other than liquor products and petroleum products, and in their case, not other than petroleum products and tobacco products, everything was compromised. We all gave it up because we all wanted to come under one particular tax system, one nation, one market, one taxation. And there shouldn't be any cascading effect of taxation. So that was the reason why all other the acts, they got subsumed, and the only act that was available thereafter was the GST Act that we had. As a student of law and of taxation law, if I have to point out 5 differences that was there between the VAT Act and the GST Act, my lords, the first of them, my lords, would be that under the VAT Act, my lords, the state was the only authority that used to collect the tax. Nothing used to go to the center. But under the GST, there is an equal share of taxation that is happening, and I will explain how that happens. The second difference that I can say is that the VAT Act used to be an entry-based tax.
So we need not go there.
No, because the judgment is passed under the VAT Act.
Yes,
the taxation tribunal judgment. So therefore, we need to understand how the VAT Act is different than the GST Act, and whether a particular officer was empowered under the VAT Act or not would be relevant under the provisions of the VAT Act. because that was the entry-based tax. Now, when it was the entry-based tax, from where the goods originated was important. But in GST, that is not important. Now, my lords, let me come to the second point. They say they have given a particular meaning, purport, and reading to section 6. They say, if I can have my lordship for a moment on section 6. They say that this section 6 has to be read in a particular way. And how it has to be read? Their reading of section 6, my lords, is, and then they relied upon a judgment also. We come to that judgment. Their reading of my lords section 6 is without prejudice to the provision of this act. So first of all, there should be no prejudice. It's start with a no prejudice. The officer appointed under the State Goods and Services Tax Act or the UT are authorized to be proper officer for the purposes of this act, comma, subject to such condition as the government shall on recommendation of the council by notification specify. They are reading it as if the power has to come by way of a notification. That is not the reading of this section. The power is already there. It is coming from 270A of the Constitution. How this has to be read? If I can have my lordship, and I will come to judgment. If I can have my lordship for a moment on section 3, on section 4, I'm so sorry, Ministers. On section 4 of the IGST Act, because both of the acts were passed at the same time. If I can have my lordship for a moment on section 4,
yes,
of the IGST Act, then it will be clear how
IGST.
section 6, yes, how section 6 of CGST and how section 4 of IGST has to be read together.
IGST,
Same parliament, same drafting. My lordship has the IGST Act. No, in the GST book itself, the IGST Act is also there.
IGST rules, IGST Act. Here. CGST. Yes, IGST Act.
IGST Act. Now, my lords, we will read it side by side.
Section?
For my satisfaction. Section 4.
Yes.
Section 4. My lords, the headline or the head of the section 4 is authorization of officer of state tax or union territory tax as proper officer in certain circumstances. In section 6 herein, same. Authorization of the officer of state tax, union tax as proper officer in certain circumstances. This also begins with without prejudice to the provision of this act. This also begins with without the provision of that. The officer, what is the difference that is coming here? Subject to such exception and conditions as the government shall on the recommendation of the by notification. So therefore, only the exceptions and the conditions has to be notified. What were such exceptions? For example, 54 and 55. There was a refund provision. Suppose the CGST intercepts a vehicle. A penalty is imposed. Half of the penalty goes to the state, half of the penalty goes to the CGST. Now there is a direction to refund. Now my money has come into my account. How will he refund it? Therefore, there was a notification published. Though not in case of refund also, the power would be similar. That was section 54 and 55. For empowerment, there is no notification that is required. That is from the reading of Article 270 of the Constitution. Now, if I can have my lords for a moment, they have relied upon a judgment. That judgment, my lords, is a judgment passed by the Madras High Court. No, it has children. They have relied upon. No. They have relied upon another judgment that was there. I was handed over a copy of the judgment.
Madras High Court, my lord, TVL. Madras High Court.
Yes, let's have a look at TVL, my lords. What does it say?
TVL to the
Hey. The BDS. The BDS. Into the Madras High Court judgment.
Yes, my lords. They have relied upon a judgment. This is 2024-160 taxman.com 771 Madras. TVL Vardhan Infrastructure. It's a single bench judgment. The Madras High Court, my lords, here is of the opinion that the officer under the central or the state tax administration cannot usurp the power of investigation on each other, and it is also of the opinion that in case if a person is registered under the state tax authorities, then my lords, the central will not.
Which paragraph you are reading?
Oh, it is their judgment, my lords. They have relied upon paragraph 62 and 63. 61, 62 and 63. Let's read, my lord, 61, 62, and 63 for a moment, my lordship. If I can first have my lordship on 61. And this was when I started practice, my senior, he used to tell me that you say one absurd proposition of law and you will find a judgment that supports it. With all due respect, my lords. Paragraph 61. The section 6(1) of the respective GST enactments empower government to issue notification on the recommendation of GST Council for cross empowerment. However, no notification has been issued except under 6(1) for the respective GST enactments for the purpose of refund. Although officers from the GST and CST are proper officer under the respective GST enactment. Since no notification has been issued for cross empowerment with advice of GST Council except for the purpose of refund of tax under chapter 11 of the respective GST enactments read with chapter 10 of the respective GST rules, impugned proceedings are held to be without jurisdiction. Consequently, the impugned proceedings are liable to be interfered and set aside. Thus, this is the conclusion, lords. Thus, if an assessee has been assigned administratively with the central authorities, pursuant to the decision taken by the GST Council as notified by the circular number 1 of 2017 bearing reference number such and such, the state authorities have no jurisdiction. This is what, my lord, the single judge of the Madras High Court has held. And this has been heavily banked upon by them. Now, if I can have my lordship for a moment on the judgment of RK Ispat. This is the division bench judgment, my lords.
May I have a copy?
Yes, sir. Anytime.
Thank you.
Herein, if I can have my lordship for a moment, my lords, on paragraph number 16. This is a division bench judgment, my lords, wherein that judgment has been taken into consideration. But before that, paragraph 7, my lords, whether the issuance of a specific notification for cross empowerment under section 6 of the CGST and SGST is mandatory, and in absence thereof, whether a proper officer under CGST Act can exercise the jurisdiction in respect of a SSC assigned to the state or vice versa. The answer, the first question of paragraph 7, my lords, starts from paragraph 16. From the plain reading of section 6, as it is, without making any attempt to read it between the lines or to give it a contextual interpretation. It had to mute or contextual interpretation. It clearly transpires that the underlying objective of enacting section is to streamline tax administration, promote judicial accountability, eliminate duplicity in proceedings, and create a conducive environment for business operation. To ensure convenience and provide a single interface for the purpose of tax administration, every taxpayer has been assigned a jurisdiction of either the center or the state. However, the GST Acts also contemplate cross-empowerment of the center and the states over the taxpayer assigned to each other. Recently, both the central as well as the state administration have been functioning under the belief that Section 6 authorizes them to enforce GST laws on taxpayer assigned to the other jurisdiction. The issue as to whether the mandate of cross-empowerment contemplated under Section 6 has been validly brought into force or not has been the subject matter of debate before various high courts, and the opinion on the issue is divided. Then, my lords, the judgment that they have referred to is being referred to in paragraph 18. So the Madras High Court has taken a contrary view, holding that cross-empowerment under subsection 1 of section 6 of the CGST Act is inbuilt and does not require a separate notification by the government of India. I'm so sorry, my lords. The view of the Madras High Court is there and it says, sine qua non. On the other hand, the Kerala High Court judgment is referred to in Pinnacle and Karnataka High Court in SLM stationery. I will also come to Gujarat and Delhi and Jammu and Kashmir and what they say. Then it says that it has been further opined in those judgments that a notification by the government of India on the recommendation of the GST Council would be required only to impose riders and conditions on cross empowerment, because section 4 of the IGST and section 6 of the CGST has to be read together. It cannot be read independently. Before we advert to the case law on the issue and the two contrary views taken by the High Court, then we'll have paragraph 21. The phrase without prejudice to the provisions of the Act would mean that the provision being enacted will not override, limit, or affect any other provision of the Act, in a sort of saving clause that ensures that the operation of the rest of the Act remains intact. To put it simply, the section functions in addition to and not in derogation of the rest of the provisions of the main Act. Paragraph 23. By virtue of the provisions of subsection 1 of section 6 of the CGST Act, the officers appointed under the State Goods and Services Tax Act and the Union Territory Goods and Services Act are deemed to be proper officer for the purpose of the CGST Act 2017. The cross empowerment is therefore inherent and automatic under the subsection. No notification is required for cross empowerment. The government is only empowered to subject cross empowerment of officer to such condition act it shall on the recommendation of the council specified by notification, unless such an empowerment is envisaged under subsection 1 shall be effectuated, is issued by the government on the recommendation of the GST Council. The officers appointed under the State and the UT GST Act shall be the proper officer for the purpose of the CGST Act. When we read subsection 2 conjointly with subsection 1 of the section 6, we further find that where any proper officer issues an order under the CGST Act, he shall also issue an order under the State SGST Act or the UT GST Act, as the case may be, under intimation to the jurisdictional officer of the state tax or the UT tax. This empowerment of officer under the CGST Act to pass order under the state or UGST Act can only be held or curtailed by condition to be specified. So that notification is for curtailment. It is not for empowerment. Subsection B of section 6(2) of the CGST Act provides for obviating duplicity in proceeding and lays down that where a proper officer under the state GST or UT GST has initiated any proceedings on the subject matter, no proceeding shall be initiated by that. That is the check and balance that is there. 26, with a view to ensuring a single interface under the GST regime and to avoid dual control over the taxpayers between central and the state tax administration be effected. The council also recognized the necessity of empowering both the central and the state tax administration to act on intelligence-based enforcement action across the entire value chain, regardless of the administrative allocation. While the single interface was envisaged for the convenience of taxpayers and to avoid dual control over them, the cross-empowerment has intended to maintain a robust enforcement mechanism and prevent any scope of tax evasion. Now we come to the circular, the 2017 circular, which is not a subject matter before my lordship still. Circular number 1 of 2017 dated 29/2017 issued by the government of India pursuant to the aforesaid decision of the GST Council laid down guidelines for the division of taxpayer between the center and the state in the following manner. Thereafter, it has been called out. We will straight away go to paragraph 29. From the careful reading of the above circular and clarification, it is evident that while section 6 ensures a single interface and avoids dual control over allocating taxpayers between central and the state tax administration, the power to take intelligence-based enforcement action is conferred under both the central and the state tax authorities. Similarly, the issue as to whether the issuance of a notification by the government is sine qua non for effectuating the cross-empowerment contemplated under section 6(1) has also been clarified. The clarification reproduced above leaves no manner of doubt that subsection 1 of section 6 provides for issuance of a notification only if government intends to specify conditions subject to which cross empowerment is to be effectuated. A notification would therefore be required only when conditions are to be imposed, and in the absence of such conditions specified by a notification issued by the government on the recommendation of the GST Council, the cross empowerment envisaged under subsection 1 would be absolute and complete. Then the other things are also there in the judgment. I will not trouble my lordship with that. The second judgment, my lords, is a Kerala High Court judgment. In Pinnacle, my lord, where here in my lord, Gujarat and Delhi has also been referred on some very similar issue. So in paragraph 4, my lordship will find that section 6 has been called down, and thereafter, my lords, internal page. Third page, my lords. The question framed is, after reading of section 6(1) of the CGST Act makes it clear that the officer appointed under the state goods and services tax or the union tax are authorized to be proper officer for the purpose of the act, unaided by authority. A reading of the provision suggests to me that by virtue of the operation of the provision itself, the officer appointed under the state goods and services are proper officer for the purpose of Central Goods and Services Act. And it is only when any restriction or condition has to be placed on the exercise of power by any officer appointed under the State Goods and Services Tax Act that a notification as contemplated by the provision of 6(1) of the CGST Act has to be issued. Then what's the next page? Because why 54 and 55 then? That also needs to be answered. On the next page, my lord. Refund. Yes. Refund, and they have been specified as the proper officer only under section 54 and 55 and not under rule 96 of the CGST Act. If no notification issued to impose any condition, it means that officer of
paragraph you are reading?
My lordship, I am below 3.3.
Below.
Page number 4, end of the.
So I just want to impress upon you that refund was an exception, and because refund was an exception to cross empowerment, therefore the 54 and 55 circular has been issued. That I had been referring to, my lordship.
Yes.
Then, my lords, paragraph number 5, my lords.
Yes.
We find ourselves in complete agreement with the prima facie view taken by the learned single judge. So this may not happen to a division one judgment. It has come in a later patents appeal by the learned single judge in the reference order. The provision of section 6(1) of the CGST Act makes it evidently clear that the cross empowerment of the officers of the SGST or UTGST department to function as proper officer under the CGST Act is through the legislative mandate under section 6(1) of the CGST Act. It is a mandate and empowerment that is presently unqualified, but expressly made subject to such condition as the government shall on the recommendation of the council by notification specify. In other words, while the statutory mandate at present is unqualified, it may be qualified in the event of the government, and that is when the notification is required. Paragraph 6, we also find that the view taken by us accord to the view taken by the division bench of the Delhi High Court in Indo-International Tobacco. Then we also in paragraph 6, paragraph 60 has been referred to from Indo-International Tobacco. That is the Delhi High Court view. This is a cited case, my lordship. Paragraph 60, yes. Section 6 of the CGST Act is clearly guided by the object of providing a common national market for goods and services and to eliminate the subjection of the taxpayers to multiple jurisdictions. It aims to provide protection to the taxpayers against being subjected to multiple agencies for the same set of transactions, at the same time empowering the officers under the CGST or the SGST Act or the UTGST Act to pass a comprehensive order and take action keeping in view the extent of the other act. There should therefore be only one order insofar as the tax entity is concerned, and that is why the 60 protection is there. Then, my lordship, on the last page, because it was brought by way of a reference, so the reference is being answered here. Thus, we answer the reference by upholding the view taken by the learned single judge in the reference order for the reasons stated herein, as supplemented by the reasons in the judgment. Further, as we find that no other issue arises for consideration of the writ petition, we also deem it appropriate to dismiss the writ petition through the judgment. Needless to say, it will be open for the petitioner to pursue the statutory remedies. Now, coming to the statutory remedies, because that is where the Kerala High Court has ended. If I can have my lordship for a moment. There are two sections, 73 and 74. We all know, Millers, what there is in 73 and 74. There is a section 107. Yes. I am just carrying from where, Millers, the Kerala High Court has left. 107. 107, Millers says that there has to be an appeal to the appellate authority. Once the procedure of, because chapter 18 of the GST Act is all about appeal and revision. Once, Millers, 107 toll gate is crossed, thereafter, Millers, it will come to 112, it will come to 112. What is 112, Millers? Appeals to the appellate tribunal. I just want to say before my lordship, Millers, that the tribunal was not functional. Now, because the tribunal was not functional, an authority, SSC cannot be left remediless. Because an SSC cannot be left remediless, we had been very, very, very generous, and we have been accepting all the writ petitions that used to come before my lordship. Even cases like these. But for a moment, what does the section 112 says? Any person aggrieved by any order passed. So any order passed under the GST Act, whether it is 73 or 74, after 107, in 112, they can go before the tribunal and they can agitate it there. Today, Millers, circular निकालो, single page जो दिया था, technical जो point हो गया वो दे. 107 or 112. And after 112, if they are not satisfied with the tribunal, then Millers, they can again come back to the High Court. Where is that given, Millers? That's 125, 125, है ना? 125 ना? No. No. 117, Millers. 17. Any person who is aggrieved by any order passed by the state bench can again come to the High Court. So in that case, what will happen? Their taxation matter will be listed at WPGST and it will come before the division bench. Now today, what is happening is the writ petitions were being allowed because the tribunal was not functioning. Now I am putting a question to myself, Millers. Today the tribunal is functioning. Under what circumstances can the jurisdiction of the tribunal be circumvented by way of presenting a writ petition? If I can have my lordship for a moment on a couple of judgments that I will be relying upon before me. The set of that starts with the Chabilal Das Agarwal. Chabil Das Agarwal. Sorry. Chabil Das Agarwal, you need a booklet. Alright, sir, anything for you. Chabil Das Agarwal was a judgment, my lordship, that was passed when the GST regime was not there, even before the GST regime. So we are trying to figure out, my lord, what the general, my lord's, law that has been enunciated in case of interference under 226 is there, and thereafter, my lords, how it has traveled before the tribunal was there and after the tribunal is there. So in Chabil Das Agarwal, my lords, section 148 notice for an assessment year, my lords, of 1995 and 96 were challenged before the Honorable Supreme Court.
Mr. Only one thing, against the order of the adjudicating authority, they preferred an appeal.
That was delayed by limitation, but I am not on that. Before the adjudicating authority, they got an opportunity. They presented their reply. The order is reasoned.
Yes.
Now, there are two things, my lordship. One is,
I'm coming to that.
one is no opportunity given.
No.
Another is opportunity given, not satisfied with the reply.
Yes.
Now, what is the difference between the two, my lord? That, my lordship, is.
No, I will come to that.
My lordship.
So against the order of adjudication, they have preferred an appeal beyond time.
Accountant failure.
So it has been dismissed on the ground that it's barred by limitation.
Yes.
Against that, they have come up before.
Yes. Yes. But they haven't gone to the tribunal. They haven't
gone to the tribunal. One of the reasons is that the order is without jurisdiction. If the order is without jurisdiction, they can straight away challenge the not, because that was Ms. Mukherjee's submission that it did not have gone to the appellate authority, could have directly challenged before this court. That was one of our submissions. Yes.
Now, in Chabil Das Agarwal, my lord, paragraph 14 onwards for a moment. My lord.
Yes.
Because section 148 notice was under challenge. In the instant case, the only question which arises for our consideration and decision is whether High Court was justified in interfering with the order passed by the assessing authority under section 148 of the Act in exercise of jurisdiction under 226, when an equally efficacious alternate remedy was available to the assessee under the Act. Before discussing the fact proposition, we would notice the principle of law as laid down by this court. It is settled law that non-entertainment of petition under writ jurisdiction by the High Court when an equal efficacious remedy is available is the rule of a self-imposed limitation. So the question, lords, is not whether it is maintainable or not. It is always maintainable. It has to be maintainable.
Entertainable.
Yes, the question is whether it is entertainable or not. However, the High Court must not interfere if there is an equal efficacious alternate remedy available to the petitioner, and he has approached the High Court without availing the same, unless, because the tribunal is functioning today, without availing the same, unless he has made out an exceptional case warranting such interference, or there exists sufficient ground to invoke extraordinary jurisdiction 226. Now, I will straight away come to Titagar. The Titagar has been, yes, next paragraph. Paragraph number 13. Titagar has been referred to there. Because what I'm trying to impress upon my lordship today is that this GST Act is a special act. It's not a general act. It's a special act. It has a complete code in itself. The order of the adjudicating authority, the appellate authority, the tribunal, Supreme Court, High Court, everything is in the act itself. It's a complete code. Now, can somebody circumvent, particularly when the tribunal is functioning, the High Court is also functioning and the Supreme Court is also functioning under 117 and 125. So can somebody, as on today, standing here, taking variety of points like a bouquet, can somebody actually circumvent the tribunal jurisdiction that is there? What did Titagar paper mill said, Milord? It is now well recognized that where a right or liability is created by a statute, for example, herein by the GST statute, which gives a special remedy. There is a special remedy that is there for enforcing it. The remedy provided by that statute only must be availed of. This rule was stated with great clarity by Justice Wills, and therefore this particular quote is my personal favorite and is also important. There are three classes of cases in which liability may be established founded upon a statute. But there is a third class where the liability not existing at common law is created by a statute, which at the same time gives a special and particular remedy for enforcing it. The remedy provided by the statute must be followed, and it is not competent to the party to pursue the courts applicable to cases of second class. This form given by the statute must be adopted and adhered. And thereafter, paragraph number 18, Guwahati Carbon has been referred to. When a revenue statute provides for a person aggrieved by an assessment, they are under a particular remedy to be sought in a particular forum, in a particular way. It must be sought in that forum and in that manner, and all the other forums and modes of seeking remedy are excluded. Thus, while it can be said that this court recognizes some rules, exceptions were recognized, but this by and large used to be the law. Now, my lordship, if I can have my lords for a moment on the next page, my lord, this is the judgment that has been delivered, my lords, by the Madras High Court. Service tax matter, my lords.
Mr. Mishra, this is a well settled proposition.
No, what I'm trying to say is
If there
all
is a-
the pending cases, all the pending cases in bank clubbed together has been sent to tribunal. That is the only thing I'm requesting.
Here.
No, in different high courts. In Odisha, it has been done. In Guwahati, it has been done. In the Port Blair circuit of our high court, it has been done.
Has to be. That has to be. That's the procedure that has to be.
That is the only thing I'm trying to impress.
Yes, please show me that.
Yes, my lordship. Now, so this Madras High Court judgment, my lords, is there. Let me have, my lords, for a moment on what the what the Madras High Court does. Paragraph number, my lords, 22, page number 22. I'm sorry. Even taking for granted that the original authority has passed a cryptic order, non-speaking order. If any appeal is preferred by the writ petitioner, the appellate authority is bound to avert the said submission. At this juncture, it would be seen that in Tata, the procedure of approaching the forum constitutional of the act has been followed. Writ petitioner can always raise tenable grounds before the appellate authority and rightly observed by the writ court that if any appeal is preferred, the consent appellate forum has to look into the substance of the reasoning and the writ petition is preferred. Now let's come to my for a moment to the Guwahati High Court. Because from here, the tribunal story starts. Paragraph number 5.
Yes.
The order in appeal in the instant case was passed on 3rd of December 2025, and as such, the remedy to prefer an appeal 112 CGST is available to the petitioner till 30th of June 2026. What happened was that till 30th of June 2026, there was a special circular that said that anybody who would approach the tribunal the limitation would be condoned. The grounds urged in this writ petition are therefore also available to be urged in the appeal preferred under section 112 CGST. Then, my lords, let's have a look at Odisha, because herein my lordship Honorable Justice Tandon, what he has done. The 4.4 for a moment, yes. It is no longer res integra that the writ court can be approached as selling an order for which the forum of appeal is provided and the same is entertainment, and even the forum is not made functional or constituted as the person cannot be rendered remedial. Equally, it is true that if conditions are attached to filing an appeal before such forum, the writ court shall ensure strict compliance thereof, and no person could steal a march before taking a shelter. Since the forum has already become provided in the statute, which is now made functional, and the period for filing the appeal has been extended in a fragmented manner, it would not be proper for the writ court to keep such writ petitions pending, as the dispute raised by the petitioner in the instant writ petition can be adjudicated by the said forum, and thereafter, my lords, the direction for deposit was there. Surprisingly, my lords, the next page, Port Blair. My lordship Honorable Justice Arijit Banerjee, he has clubbed together as many as 23 writ petitions. In paragraph 12, my lord, there is a table that is given. Some of them were beyond limitation, some of them were on other grounds. Paragraph number 8, my lords. The tax period has been explained. Several judgments have been relied upon. This is our own circuit bench, my lords. Then the court's view start from paragraph 26. Having heard learned counsel for the parties, to my mind, the following issue call for adjudication. Whether the present writ petition, all these are pending writ petitions that is there in the Port Blair bench. Whether the present writ petition should be entertained, notwithstanding availability of an alternate remedy in the form of a statutory appeal under section 76 of the regulation. And then, Lord, the answer to that, my lordship, is paragraph number 30 onwards. And all of them has been clubbed together and sent to the tribunal. Just one more thing, lords, I will be relying upon. Paragraph number 59 for a moment, lords. Page 75. Page 75. The page numberings are there at top center.
Yes.
The appellate tribunal order is stated to be final, subject to a review by the tribunal. The VAT regulation is a complete code in itself. In my opinion, the writ court should be very slow to interfere in respect of orders which are appealable to the tribunal. Tax disputes are also more effectively and conveniently adjudicable before the tribunal rather than the writ court. I am conscious of the line of cases which say that once a writ petition is taken on record and affidavits are exchanged, at the final hearing, the writ petition should not be dismissed on the ground of availability of alternate remedy. However, those cases may not be relevant if at the final hearing, the writ court is of the opinion that because of existence of disputed question of fact or for any other reason, the alternate remedy should be resorted to by the writ petitioner. I am of the considered view that this is a case where the dispute between the parties which pertains to a fiscal statute and to the extent are factual in nature should be adjudicated by the appellate tribunal. I do not think that just because the writ petitioner was permitted to file this petition in the absence of a functional appellate tribunal, the same would give the petitioner any vested right to have the disputes adjudicated before a writ court. I therefore direct that the records of all those writ petitions out of the bench of 47 petitions which has been heard, and all of them has been sent to the tribunal. That will find is in paragraph 65. 47 writ petitions which are being disposed are sent to the tribunal. Today, my lordship, my contention before my lordship is that there is already technical member of the central that has been appointed. This, my lords, I am referring to is a news article on July 15, 2026, wherein one Anindya Mitro and one Malay Ghosh has already been appointed as technical member of the state in the GSTAT. The GSTAT is sitting with 6 courts. There is cause list coming on a daily basis. It is very much operational and functional. Anything and everything that they have to say here, including, because in every case there is a violation of natural justice. So in anything and everything that they have to say, including the violation of natural justice, can very well be agitated there. Why should High Court have all the fun? Let the tribunal also have some fun. There is no requirement of keeping this matter pending here. It can very safely be relegated to the tribunal, particularly in cases like this, wherein opportunity was given. They have availed that opportunity. Thereafter, everything is thrown over an accountant. That accountant is missing. He is not here. He is the demon of the story, but he is not a party here. There are a lot of factual things that needs to be looked into and gone into. Let that be done by the tribunal. That is all means that I have.
Mr. Bonik, anything you want to
my
add?
submission is also that
Yes.
section 6
My
is
lord.
very, section CGST. It is very clear that the officers of CGST as well as the officers of SGST both are same power in view of the section 6 of the CGA, which is also my humble submission from the day one. Section 6. Very clear. Nothing more. Another order. Yes, sir. Section 6 is clear. This is my submission.
Yes.
My lord,
Yes, Ms.
may I
Mukherjee.
make my response? I'm making, yes, my lord. My lord, I have
Yes.
heard both the learned additional advocate general, assistant additional advocate general, and Mr. Bonik. My lord, the state representative, the state's views were first on the facts of the case, then on the ITC unit, then on cross empowerment, and then on alternative remedy. It seemed to me that the response of the state is that just because I have gone in appeal, therefore I should go and avail the second appellate tribunal. But my lord, I have challenged the jurisdiction of the authority to issue the show cause notice and also the adjudication order. And because I have been advised by somebody and gone to the appellate authority,
No, Ms.
it does
Mukherjee, only
not
one
mean
thing.
I have waived my.
Ms. Mukherjee, only one thing. Only one thing.
Yes.
Yes. Merely because there's an alternative efficacious remedy available under the statute, it's not that the power under Article 226 and 227 is taken away. But
yes, ma'am.
Here is a statute where it says that from the order of the adjudicating authority, there is an appellate authority provision. Thereafter, the tribunal Thereafter, an appeal lies, statutory appeal lies before the High Court. And the provision is more or less akin to Section 100 of the Code of Civil Procedure. Appeal can be admitted only on substantial questions of law. Now, it's one thing,
Yes, my lord.
at some stages, you challenge a jurisdiction, but when an adjudication order has been passed, which is an appellable order, whether, and before the appellate authority, you have also approached before the appellate authority. Once you have taken that recourse, now after you have failed in your attempt before the appellate authority, now can you come and avail of 226? Because High Court's power,
Yes, ma'am.
and that's before the division bench. That's its
Yes.
point which you have to satisfy. I can give you
Yes,
time,
ma'am.
please make a research work
My
on
lord, I
this,
submit now.
because
My lord, first let me submit today. My lord, I will make my submissions on certain matters. Thereafter, if your lordship is not satisfied, I will do further my research.
complete,
My lord, first
not
on
in,
the-
not in piecemeal.
My lord, I'll complete
Ms.
it.
Mukherjee, not,
My lord,
not,
my lord,
not piecemeal. You please get ready, come tomorrow. Please make your submissions as a whole tomorrow.
my lord, first,
Yes,
my lord.
on all
On
points.
this ground, my lord,
because,
my lord, kindly hear me.
Yes.
My lord, I have a judgment of the Supreme Court. My lord, the learned counsel
Yes.
had relied upon the judgments of the High Court. Now, my lord, your lordship knows very well, in the matter of jurisdiction, the judgment of the High Court, which forms the bedrock for issuing writs, prerogative writs, my lord, is Whirlpool Corporation. My lord, my learned junior, Mr. Anirban Chatterjee, I am requesting him to submit the copy of the judgment.
Ms.
My lord,
Ms.
I'm not
Mukherjee, I
aware
have
if your lordship
considered,
has.
please consider, yes, I have also considered that judgment when there is a statutory remedy and the efficacy of that. I have
My lord.
recently delivered 2 or 3 judgments on that. Please consider that. That is why I'm giving you time. Because I've considered almost all these judgments, starting from Whirlpool, taking to PHR invent, which was also considered in a division bench judgment in the Port Blair bench. Please consider those judgments, because I had the occasion to consider all this. And that was also on a point of jurisdiction. I'm
My lord,
telling
I will
you,
do that.
on a question of jurisdiction, though under the Land Reforms and Tenancy Tribunal Act. So please go through those, because that was on the ground of jurisdiction. One is on the ground of Section 5 also. So that is why please go through those, because those are in my mind. That is why I'm giving you time. Please go through that and then make your submissions. Because I'm well aware of the provisions of 226, 227, alternative remedy is not a bar. Yes, even then, when the statute creates a forum, whether you can be allowed to bypass after being availing of that recourse to some extent, then coming back and saying, no, I will avail 226. Please consider those line of decisions.
So, my lord
And
is
recent
fixing it.
decisions of the Honorable Supreme Court I have also considered in my that judgment.
My lord, may I see the name of the judgment, my lord, which your lordship has considered?
Name of the judgment is difficult.
My lord,
I'm telling you on West Bengal Land Reforms and Tenancy Tribunal
my
Act,
lord.
within 2 or 3 months, I have delivered 3-4 judgments on
My
that.
lord.
I can give you the advocates who appeared in one matter. Mr. Thakkar appeared. In one other matter, Mr. Parthapratim Rai appeared. And in another matter, I think Mr. Abrotosh Mojumdar and Mr. Devojyoti Basu appeared. So I've delivered 3 or 4 judgments on these issues. And in most of them, on jurisdictional issues also.
I'm deeply obliged.
Heard Mr.
One more submission. I would like to submit that the member of the state has recently been appointed, but the member of Central CGST Already.
Long
appointed
back.
since now.
Long back.
Already appointed.
In month of
And-
May, they
and
have
the
been.
Tribunal is
Please
functioning.
give those
Yes, yes.
particulars to them, let them consider, because if the tribunal is functional,
Yes, yes,
then
yes.
it's one thing.
Yes, yes.
Heard
Lord,
Mr.
one
Learned, Assistant Additional
My
Advocate.
lord,
General.
one indulgence. In this matter, the learned Assistant Advocate General actually reiterated 2 points, but another point is that jurisdictional officer posted in Bureau of Investigation. The
Yeah.
circulars is ambiguously clear that though
I have
he
understood.
retaliated by the
Sir, if the order is an appellable order, if that it goes jurisdiction, everything can go there. That's the primary point, which is the thing, because here also an appeal lies before the High Court division bench on a substantial question of law. Whether at this stage under 227, 226, you can take that route. On merits, yes. If I entertain on merits, all points will come.
My lord, there is also one thing, there is a high pitch demand is staying at my face and
Tomorrow I am keeping.
my lord, then madam, then
Yes,
my
my
lord,
lord, my lord.
in its
My lord, let it retain its.
in the top of the list, my lord, if lordship may permit.
Heard Mr. Learned, Assistant Additional Advocate General, to stop for the reply argument of, and Mr. Boni, Learned Advocate, appearing for the CGST authority. So for the reply argument of Ms. Mukherjee, list this matter tomorrow under the same heading. Yes, Mr. Banerjee, tomorrow I am. Yes.
Second half.
Matter came up on Friday, Provident Fund, we wanted installments. I wanted, Lord,
Tomorrow I am
for both pairs coercive measures, they said
Okay,
we take
that one.
instructions,
Second
that was
half.
posted today. In the meantime, on Saturday, they have got an arrested, Lord, a person who is not even a director, but the person who is actually the whole and soul of the company. He's behind bars. Now,
Tomorrow I
he
am
has
keeping
paid the entire money.
You have paid.
Paid the
Who is
entire
appearing for the Provident Fund authorities?
money. If he can be released, only that much for today. The subject matter, Lord.
Lordship is still taking time because of I have some information. Just received many information. So for the payment.
What do you say? Some person has been arrested.
Yeah, that is not been related to this repetition because of the FIR has been lodged on 23rd July, and in connection that was one of the arrested. This is not.
All right, Mr. Banerjee, I'm keeping it tomorrow. I will hear this.
Lord, I paid up the money also.
What is your item number?
It is number 60, my lord, 60.
60. Eta kalke to upore diye. List this matter tomorrow. Mr. Banerjee, Learned Senior Advocate, appearing for the petitioner, submits that there is urgency in this matter. First up, the Learned Advocate for the Provident Fund Authority is present. First up, list this matter tomorrow, hire on board.
Supplementary affidavit.
Supplementary affidavit filed in court today is taken on record. A copy of the supplementary affidavit is already served upon the Learned Advocate for the Provident.
Lordship. My lord, can you?
My lord,
Lordship. Is the matter at 2 p.m. tomorrow?
Tomorrow?
Lordship. 2 p.m.
Sagar Ghosh,
Sagar
Lordship
Ghosh.
Sagar Ghosh.
The other matter?
Yes, but just previous.
If it is taken up prior to 2, please mention it.
Lordship, one.